Item number 1. Item number 2.
Item number 2, may it please your lordship. Annex 8 is the order impugned with the honorable single judge. But before your lordship take through the impugned order, would I take your lordships to the documents file heading? Kindly turn to Annexure 1, which begins at page 15. Annexure 1, page 15, which is the gradation list of Group D employees to be promoted to Group C. Now, my name is at serial number 17, page 16.
Gopabandhu Sahu.
Yes. Now, next to Annexure 2, on 14th of March, the District Education Officer,
14th of March, which year?
23, called upon the block education officers and the headmasters to submit the names of those persons, peons, who are willing to be promoted. That's the requirement, having completed 10 years. Now, pursuant to this order at 14/3/23, I submitted my willingness. And that is at page 23, which the headmaster of the school has communicated to the district education officer. At the bottom of that page, my lord will see my application of Gopabandhu Sahu's willingness to be promoted to Group C.
When?
25/3/23. Next, what happened? This is the most interesting part. And it's a 4 at page 24. On 16th of May 23. No, 16th of May 23. The district education officer, Keonjhar, called upon the block education officers, Keonjhar, and headmasters to
Education officer.
district education officer, Keonjhar. He issued an order communicating to the block education officers and also to the headmasters of the school that you please depute these persons. And he had made his own list. And he has made his own list, ignoring my willingness. That your lordship will find at page 26. Group D employees who are to appear computer skill test examination on 18/5/23. 16th afternoon, the order is issued. 18th, 9 o'clock will be the exams test. And my name doesn't find there. So I had no occasion to know that. Just within one day, the list was prepared, test was held, and ultimately they were also promoted. I didn't know they were promoted. So I challenged that in the writ petition. The Honorable Single Judge if your lordship goes to Annex 8, the impugned order, I would beg your lordships to see the orders passed in that case. There were 3 cases listed. And
Relief was granted to you.
sorry,
Relief was granted to you by the grant.
relief was granted to me in the sense that they will hold the exams in December. Till then, they have not done. Now 2 months have passed. Now your lordship will kindly see the most interesting part is kindly see that order of the Honorable Single Judge.
Honorable,
Single Judge.
it is there before.
No, that's not there.
Annexure 8.
Nice Tagul. Before that, the Honorable Single Judge by order dated 3/7/23. I've given that my type copies. It is contended that while fixing the date of skill test on 18/5 so and so, the OP number 3 has only allowed 1 day time to the Group D employees to take the test. Mr. Samudra Leonard contended that since the letter dated 16/5/23 was not brought to the notice of the petitioner duly, and only 1 day was allowed, he could not appear, etc. Now at para 4, the Honorable Civil Judge says, the AG is directed to file an affidavit through OP number 3, stating the reasons for taking the test just 1 day of issuance of notice on 16/5/23.
We are not able to understand only one.
Yes, my lord.
You have been able to establish that you were wrong. All right?
Yes.
Now,
That's right.
what order could have been passed other than what has been passed by the learned civil judge in that case?
My lord, in that case, what I would submit, what weighed with the Honorable Single Judge was that by that date, on 18th itself, the final list was prepared and people were given promotion by DPs on that date itself. And those people who filed intervention petition saying that, no, sir, we have already been appointed. And the court said, yes, they have been appointed. Okay, you give them another chance. Me in particular.
So what order could have been passed?
I am challenging the very selection itself that we are not required to go through the computer test. It's not necessary.
So they were also not required.
Sorry.
They were also not required to do. The persons who have been selected, they were also not required to go through any selection skill test. How do you say that?
Or I beg apology to your lordships that in the order of the Honorable Single Judge and in the writ petition, I could not bring in 2 documents because I came to in hurry to the court. In fact, it was not required because I, along with 6 others, had gone to the tribunal, State Tribunal 2014-15. And the tribunal, I beg your lordship's pardon, that's not on record in the court.
Huh?
I beg your lordship's pardon, that is not on record in the writ petition. I brought it here to your lordship notice. I have also challenged that part of the order.
Then you can file a review.
My lord,
You can take a plea that despite due diligence, you could not bring to the notice of the court certain facts relevant for determination of your right.
no, in fact, what I beg to submit to your lordship is that. No, could your lordship,
In the writ appeal,
your lordship would not
We-
take note of that. I am
we-
conscious of that. That's why
our-
at the outset I
our-
said,
You are very fairly, you have suspicion.
one beg your lordship, pardon. Page 43. Go. Page 42, Annex 7. The department, district education officer says,
So this page 42 was not there in the. Take a chance.
what I beg to impress upon the appellate court is that, in fact, I was considered without a computer test. And I was not considered selected because of my seniority position. That your lordship will kindly see at page 43, para 11. Page 43, para 11, the order. The district education officer says that yes, pursuant to orders of the tribunal, we have conducted a test, not skill test, not computer test. And at para 11, they say, this man, Gopabandhu Sahu, were not selected according to the seniority for which their prayer for promotion to the post of junior clerk could not have been taken into consideration. So I was considered once. Now, ignoring these facts, he himself considered me. Now, my application dated 25th March.
Only, now remedy which is available to you is to file a review application.
Hmm? That liberty, that liberty may be given to me. That liberty may be given to me to bring that on record before the Honorable Single Judge.
Yes,
The worst part is, after all these orders, on 3 occasions, the Honorable Court said that, look, what is your affidavit? How could you conduct the test on the very next day? 16th evening, you pass the order. And 18th morning, you hold the test. And that order has to be circulated all around the state. How could you do it? On 3 occasions, they didn't turn up. They didn't file affidavit. And ultimately they said, sorry, we are wrong. And we will hold it in December. There was no material with the State Council to show that, yes, this is the order. On oral instance, he said that on December we are going to hold the test and he will be promoted.
Find against 2023. Passed by alerted single day of the sport in WPC number 17447 of 2023. Most member of the appellant has brought on report and is relying upon certain documents which were not there before the next. Learned counsel appearing on behalf of the appellant has submitted that those documents have great bearing on the merits of the case and the appellant's claim for promotion to a Group C post. So he further submits that despite due diligence, those documents could not be brought on record in the writ proceeding. So next, considering the submissions advanced on behalf of the appellant, we are of the view that the appellant said be at liberty to that the ground taken may be valid ground for seeking review of the order passed by the learned single judge. So we accordingly dispose of the present appeal with liberty to the appellant to seek review of the order under appeal. So we make it clear that any observation made in the present order shall not be treated to the an opinion expressed by.
He said that what weighed with all single was that all those 18 interveners, they came up to the court saying that, sir, we have already been appointed, we have joined. Therefore, the court felt probably that I shouldn't disturb them. And that is reflecting the order at page 6.
Item number 3.
May I please your lordship? If the appellant has challenged the judgment of Honorable Single Judge under Annexure 1, my lord, by which the appointment of the appellant was quashed and directed for fresh issuing fresh advertisement, even though, my lord, the respondent has not prayed for challenging the appointment of the petitioner. The respondent one being the candidate for the selection was participated in the selection process and not being found suitable. They is
Filing the writ petition.
respondent one has filed the writ petition.
Respondent one is principal secretary.
Oh, my lord, Amit Kumar Sahu. Amit Kumar Bhoi.
Amit Kumar Bhoi is
My
the
lord.
respondent. All right. He filed the writ petition.
The writ petition before this honorable court in the 2016, my lord, and by the impugned order dated 31/10/2023, my lord, the honorable single judge has quashed the appointment of the petitioner, even though the petitioner was continuing since last 8 years being found suitable in the selection process. Until that he is continuing also, my lord. And the honorable single judge, while passing the judgment, has quashed the order of the appointments, also the selection process. My lord, the respondent number one also, as per the advertisement issued for the post of secretary, my lord, for the society, Bhadra Cooperative Society, and pursuant to the respondent one and the appellants, also other candidates has participated in the selection process.
So you are opposite party number 8.
My lord, I am the opposite party number 8. And there was no interim order. I am continuing, my lord, before the single judge. Finally, my lord, even though the respondent number 1 has not prayed for quashing of he has, after being not found suitable in the selection process, he has challenged after participating in the selection process and could not able to success. Thereafter, he has challenged, my lord, the process of selection. Not my appointment has not been challenged. Your lordship, the honorable single judge has quashed the entire selection and also my appointment, even though I am continuing on being found to merit in the selection process. And that is, my lord, I am challenging the judgment of the honorable single judge passed under Annexure 1, my lord. Lordship,
He did not have the resident certificate.
my lord, he could not have the residence certificate, valid residence certificate, and that is the reason he could not able to brought in the merit list, my lord. The scrutiny he has been, his candidature has been rejected. Thereafter, my lord, the proceeding was of selection committee. Your lordship may see the Annexure 3, page 68. Proceeding was entire proceeding of by a properly constituted.
So this is an admitted position that you did not have the resident certificate.
My lord, the admitted position, my lord, the advertisement date was between 8 to 10 to produce the same. On your lordship, the last date was 8 to 10/11/2014 is the last date. 10/11/2014. My lord, on 8 between 8 to 10, the submission of application. On 8, I have produced the application with an undertaking that I have applied along with the revenue authority receipt. That the phrase, I have the residence certificate, but the phrase they wanted the within 6 months. That is why I have given the undertaking along with the receipt that I have applied. So soon after with an undertaking, I was filled up the application on 8. Last date was 10. On 11th, immediately I got it and I produced it before that. Thereafter, my lord, after 1 year, the selection was conducted and the merit list was prepared and everything.
He had not given an undertaking.
He has not given the undertaking, nothing, my lord.
So whether it was permissible for you to give an undertaking and seek time for filing your residence certificate?
My lord, since I have given the proof of
There is no question. The question is that if you did not have the certificate as on the last date of application, you were not fulfilling the conditions of the advertisement.
my lord, I have the certificate, but not fresh certificate. That is why I have the
validity period ought to have been lapsed. So they must be requiring the certificate, current certificate within 6 months.
within 6 months.
Within 6 months
So
from the last date of filing application, right?
Since, my lord.
So
Only the certificate they have given, that not a fresh, or that is, my lord, along with the residence certificate. My lord, since they have allowed me and undertaking, and I have given that I have applied through the revenue Tahsildar, and this is the counterfoil I have given. Counterfoil I have given, and
the question is,
my lord,
the advertisement required for you to place your residence certificate before a particular date with no relaxation in the advertisement, then you are not eligible. As simple as that.
my lord, in this, your lordship, because
So many persons who did not have the residence certificate would have made the same undertaking as you did.
Lord, there is no bar for them to apply for them because I
There is
have,
bar because of the advertisement, in terms of the advertisement.
like me, they could have, my lord, in this connection, the judgment of our own High Court, my lord, that your lordship, the In another case, my lord, in the special election, tribunal while casing the proceeding that in the matter of Vivekanand Samal versus state of
We need to keep in mind that we are in intra-court appeal. So the logic, the reasoning given by the learned is that is valid.
my lord, this is the same issue as before the honorable tribunal. State and your lordship, the division bench has hold that while passing the procedure that the matter had admitted that not produce any certificate showing qualification and the provisional certificate issued by the authority. Delay of issuing certificate was not attributable to the petitioner at all. Mere fact that the certificate was not able to obtain by the petitioner prior to March 2010 cannot be a ground to hold that petitioner is ineligible for promotion. Impugn order is set aside and read allowed. This is the division bench.
Will not apply. There are two reasons. Say that judgment does not lay down any law. That even if you don't have certificate, you can do that. It does not lay down any law. And second is that the facts of that case are entirely different apparently.
That is
So that was the case of delayed issuance of certificate. Here you made your application after 8 and you got your application on 11, the certificate on 11.
Well, the only issue, my lord, since I have given and the authority has allowed me, and I am continuing since the last 8 years, my lord, the proceeding was conducted by the properly constituted committee, and they have allowed me to participate. And just same day, my lord, or the next day, I have given. And my undertaking and the counterfoil receipt I have
They have
given, my
allowed
lord.
you to continue
My lord, I am continuing, my lord.
despite this court order.
My lord, court, my lord, I have approached before lordship, and now, my lord, the matter is.
Because you oppose this court, they have allowed.
No, my lord, there was no interim order in the before the honorable single
Where
judge.
is the question of final order was passed?
That I have approached before lordship, certain.
Therefore, we are asking, was there any interim order passed? How are you continuing? Your society is under contempt.
No, I am, since the matter is pending before your lordship,
New advertisement must have come
no,
as per direction of this court.
Then they have violated.
I don't know whether
Who is for the other side? Yes,
No, I am for the state, my lord. Society, they
I
are.
am for the opposite department. Here, in this case, a fraud has been committed. Because as per the advertisement, there is no provision for that 6 months prior to the last date of application, these resident satisfaction will be produced. Subsequently, they changed. After the advertisement, when the advertisement was changed, he has filed a petition that application, the undertaking of
Representing whom?
Madam,
You are appealing for whom?
for the OP man.
Which OP?
Respond number 1.
Respond.
Amit man.
Who is for the society?
Society.
No one is, because we cannot appear for society. I am just appearing for opposite party number 2, 3, and 4.
Dear of the view that's the
My lord, only one submission, more submission, my lord. As per the Odisha Cooperative Society Act 1962, my lord, there is alternative remedy 67B is there. Though, so in the matter of the society service dispute, my lord, the society is the jurisdiction. So the Honorable Single Judge has, since the statute provides 67B of the Odisha Cooperative Society Act 1962 provides, my lord. So any dispute regarding the service and cooperative society matter is, my lord, the cooperative tribunal is functioning, and the matter can be adjudicated relating to the service condition, everything, my lord, by the society. So the Honorable Single Judge, without going to the alternate remedies.
Now, if we remand the matter back to the appellate authority, what the appellate authority will do?
Appellate, my lord, this is the cooperative tribunal.
Yes, cooperative tribunal. What the tribunal will do? Will decide against what has been held by the High Court.
No, my lord, I am just bringing your lordship's attention that there are alternative remedies there.
Appellate. Number 1940/2016. By the respondent Amit Kumar. Wait. Stop. The appellate and respondent number 8, where applicants for the post of the Secretary of Bhadra Service Cooperative Society. Stop. Agreed by a selection list prepared by who was part number 7? In the
Seven is the society, my lord. Secretary of the society.
7 Bhadra Service Cooperative Society, page 15.
bracketed in Annexure 4 of the petition. The respondent number E and while the petition will appeal that the appellant was wrongly held to have qualified, has been declared qualified for the selection, though he suffered disqualification as he had not used the residence certificate on the last date of submission of application, that is 10/11/2014.
10/10/14.
10/10.
14. Last date of application.
10/11 or 10/10?
10/10/10.
Sorry.
10/10.
The 10/11.
No.
10.
10/10/14.
I have, sorry, I have mentioned.
Stop. It is an admitted position that the case of the respondent was rejected by the selection committee on the ground that he had not submitted his residence certificate while making his application. So stop.
No. Residence certificate within 6 months from the last date of the application. He has produced the old one, which is expired.
Valid residence certificate. All right, valid residence certificate.
Valid rights.
So, taking into account these admitted facts, pleadings on record, and the submissions advanced on behalf of the parties with reference to various decisions of this court and Supreme Court, the single judge in paragraph 26 as under paragraph 26. When counsel appearing on behalf of the appellant has argued that while making his application for selection, he had given an undertaking that he shall submit a valid residence certificate within
Soon after receipt of the
soon after receipt thereof by a competent authority. Stop. He also submit that on 11/11/2000
11:10, sorry.
11/10/2014, he had in fact submitted a valid residence certificate. So accordingly, his application was considered for selection and he was finally selected for the post. So in such view of the matter, he submits that the reasoning assigned by the learned single judge for allowing the writ petition filed by the respondent is unsustainable. So he has further argued that there is provision of appeal before whom?
Cooperative Tribunal,
Before the cooperative tribunal under section
67B,
67 capital B,
yes, capital B,
67 capital B
of Odisha Cooperative Society Act 1962.
of Odisha Cooperative Society Act 1962.
62.
The top. The respondent, without availing the alternative statutory remedy of appeal, approached this court by filing the writ petition, which was wrongly entertained by the learned signature. And for the same reason also, the impugned order deserves interference. Next. Learned counsel, Mr. So-and-so has appeared on behalf of respondent number, on behalf of the private respondent number one, on behalf of the respondent. So, we have carefully produced the impugned order of the learned single judge and given our thoughtful consideration to the submission advanced on behalf of the appellate. Stop. We reject at the outset the submission advanced on behalf of the appellant that the impugned order of the learned single judge is not sustainable because the writ petitioner, before approaching this court had not availed the statutory remedy of appeal. So, it is right that alternative statutory remedy is not a bar for this court to entertain writ application under Article 226 of the Constitution of India. So, stop. Secondly, learned counsel has not been able to satisfy that the advertisement inviting applications did contain any provision for relaxation for submission of the residence certificate beyond the cutoff dates prescribed there. So, in such circumstance, when single judge has taken a correct decision, taking a correct view that the appellant was not qualified for being considered in the process of selection. So, next, we are surprised to hear from learned counsel for the appellant that despite this court's order, which is under challenge, he is continuing continuing on the post for which he was selected, despite the selection process having been held to be, despite his selection having been caused by the learned single judge. So, stop. This, in the court's opinion, amounts to contempt of court. which can be seen in appropriate proceedings. So we do not find any merit in this appeal, which is accordingly dismissed.
Item number 4.
In item number 4, my lord. Item number 4, may I pray your lordship may call this matter tomorrow along with WA number 3105 of 2023, 3106 of 2023 and 3081 of 2023. All three matters are connected matters. If it will be called tomorrow, my lord, you can.
Tomorrow, those matters are coming.
No, my lord, I am praying for to tag those matters along with these matters so that all these matters can be taken up.
Yes.
Please, Lordships, it can be,
Please give the list.
And
This is the matter tomorrow along with.
3105 of 2023, 3106 of 2023, and 3081 of 2023. In all those cases, Mr. Mahathi is also appearing.
All these cases were disposed of by the honorable single judge on the same day.
Issues are same.
Yes.
Issues are the same, Lordships.
Issues are same.
Item number 5.
Number 5, my lord. Still there is one defect, my lord, as pointed out, my lord. I pray for 3 weeks time and then to remove the same, my lord. And in the meantime, my lord, the other batch of cases was admitted and notice was issued. That is with regards to.
But have you removed the defects?
My lord, within 3 weeks time, my lord.
Huh?
3 weeks time, my lord. Still there is one defect, my lord, left out,
Move it.
my lord. Within 3 weeks.
Time the route for. When counsel for the. Appellate
My lord, petitioner,
Commissioner
my lord.
to remove it. As pointed out by the staff.
Item number 6.
Please, Lordships. Lordships, this is a case where I have impugned an order of the learned single judge.
It has come for order
Yes, Lordships, in fact,
or.
this is first thing.
Item number 7, of 2005. Dispensal, I know that. Yes. Where is the requirement under the? This is 5 or 25 copy. Okay, please examine. Yes.
So, Lordships, the impugned order is at page 53. The learned single judge, without deciding the matter, it was a writ petition, where, Lordships, I had challenged that my first posting, which was a requirement, Lordships, as per the advertisement, was not given to me. And I was placed in the serial number, which is much lower to what, Lordships, where I should have been. And the single judge, without deciding it, had in fact directed that my representation would be heard within a period of 4 weeks. Now, Lordships, that 4 weeks has come to an end. Even now, my representation has not been decided. Lordships, prior to that, Lordships may have a look at the representation that I had given, which is at page 46.
But what is legal infirmity?
Lordships, the infirmity, Lordships, what would happen now is that, Lordships, I am in a situation where, Lordships, they have not yet decided on my representation.
That they are duty bound to do.
They are duty bound to do. Now they have not done it. Again, I go back to the same judge for, Lordships, maybe filing a contempt.
That is the procedure.
That is the, yes, Lordships. But thereafter, Lordships, the contempt, again, notice would be issued on the contempt. And supposing they do not decide in my favor, Lordships, they do not decide in my favor, Lordships, again, I would be having to go back to the single judge.
Yes. We are listing his appeal after a week.
Well.
And the nature of grievance which is being raised is.
I understand.
Lordships, because,
All right.
Lordships, she was in the SD category. Please, Lordships.
Let it come after one.
Please, Lordships.
Item number 7.
Please, Your Lordship. Your Lordship,
7.
Your Lordship, order dated 7/8/2023 has not been complied, my lord.
It's IFCO, my lords, where it's a private organization, office has to go, we don't have to.
Okay. Which, for this party? Notice to go to home.
4 and 5, copy number 4 and 5. In read petition.
Huh? 4 and 5.
4 and 5 in the read petition.
5 in?
Private opposite, but IFCO. Managing Director IFCO and General Manager IFCO Project Paradip.
You have not given their name.
Name, I have given name. One Uday Shankar Aswathi.
For this one, it is number 1 and 1 and 2.
2, 1 and 2.
Item number 8.
Yes, item number 8 and 9.
8,
Those-
9, 10.
28 capital A application which is directed to dispose of. Lordship, in other cases have been pleased to grant me 8 weeks time to dispose of the same, Lordship. The Lordship may also.
Yes. 8, 9, 8, 9 and 10.
8 weeks. And it's on behalf of the state to report compliance of this court.
Item 11.
Yes, item number 11, similar matters, Lordship said directed me to comply
because it's a batch of service matters. Because in 2-3 cases we had already complied, others we are in the process of complying. Because my friend says similar matters are coming tomorrow. If you also take it up tomorrow along with all those cases.
Tomorrow, Your Lordship posted the batch of matters tomorrow.
We are saying this.
Right. Item 12.
Non-compliance dated 11/1/2023, my lord. Lordship directed, direction was case 9, my lord.
Page 9.
Yes, my lord. The petition of representation held under Annex 8 dated 11th October 2020 will be examined.
Also grant me time, I will obtain first contempt, I will obtain instruction whether the repentation disposed of not. First contempt. No.
Seek instruction and for compliance of.
Item 13.
Minor. This is the contempt is arising out of the writ petition number 31164 against the authorized officer ICICI Bank. Minor. This honorable court directed to supply the statement of account. Till that they have not supplied to us. So that yes.
I accept notice. I accept notice for the bank.
Then why are you not complying?
We have provided. We have provided through a letter, registered post sent to him. Yes, he replied along with all the statement of accounts. He has we received that also through registered post. I have a copy of the letters.
Council must not be knowing about.
Minor.
And I have a tracking also.
And kindly supply, let me take instruction.
If it's applying, you can get it right now.
Yes.
Has been stated at the bar on behalf of copy order the statement of bonus house has been sent to the petitioner. Copy of the set account of the given account, copy of the statement of the loan account has been handed over to the council for the petitioner.
But I'll do it today in the course of the day.
Shall be handed over to the council for the petitioner today by the council representing the country. Cannot from 10%.
Opposite party bank will not.
No, there are
Authorized officer.
three parties. You are for ICICI
I'm
Bank.
for the ICICI bank. Now, the copy of the contempt petition may be served on.
Yes, I will.
Obliged.
Item 14.
Obliged. Read your votes.
May it please your lordship.
This is a case. This is regarding appointment of chairman of the committee, if your lordships have recollected. The lordships had granted us time till 15th of March. I had said 4 weeks and the lordship had listed on 15th. In the meantime, the committee has been constituted.
Lordship, let it come on 15, my lordship, so that the order can be passed both in the interim application and the contempt type application, my lord. Let it come 15. Yes, my lord. I'm passing on the order, my lord. The
Yeah. Suppose the order passed by this court.
That is order dated
16th of February, my lord. In the writ petition number, my lord, 20481 of 2023, the matter has been fixed for hearing of 15th of March, my lord. Let it come on 15th of March, slide.
Paragraph 3 also posted the. Your lordship will see the last order of February by my lords. 16th February. Your Lordship,
20481, my lord.
20481 is the writ petition. I have given your Lordship's last order dated 16th of February 2020.
In the interim application number 1970.
16th February 2024 is my Lord's last order. My Lord's have it, my Lord, order number 4.
Yes.
And if my Lord's kindly turns over the page. Mr. So-and-so representing the state based on instruction which he has received has informed this court that chairman of the committee shall be appointed within a week from today. List this matter on 15th March. My Lordships have it?
Yes.
I have given another memo, and if your Lordships kindly have a look at it, there if your Lordship sees not, I have enclosed constitution of the committee on the 2nd of March 2024, well before the date given. So really nothing survives in this anymore.
Lordship, what may I pray, my lord? Mr. Acharya is leading me in this matter. He's not well today. May the copy of the memo be.
The matter should remain pending.
Lordship, what I'm praying, my lord. Later, copy of the memo be served. I will take instructions. Mr. Lordship, as the matter is coming on 15th March, my lord, next week. And Mr. Acharya is on accommodation today, my lord. Lordship,
It will do its, it will be a job.
Lordship, may I pray for this matter to be taken off 15th March, my lord.
We'll record your. Following order was passed by the Board of Substitution on 16/2/2024. About in WPC number 20481 of 2023. So, Mr. Parija Learned, Advocate General, representing the state of Orissa, has produced before this court, a notification issued by number JTA-04/2024/2933/L Bhubaneswar dated 24/3/2024.
Second March.
22nd March 2024, which 24 relating to constitution of a committee for supervising the process of inventorization of valuable, including jewelries stored in the Ratna Bhandar of Sri Jagannath Temple, Puri. So, the constitution of the committee is as under. The present contempt application has been filed alleging disobedience of this court's order dated
29 September.
29 September 23.
2023, passed in WPC PIL number 20481 of 2023. By the said order, under the said order, the state government was required to constitute a high-level committee under the chairmanship of a retired judge, either of the High Court or of the Supreme Court, to supervise the conduct of the inventory as well as to determine its modus operandi. So, next. When counsel appearing on behalf of the petitioner has submitted that Mr. Acharya and senior counsel is unwell and therefore the matter may be adjourned. So, next, in our opinion, in view of the notification dated 2/3/2024, which has been produced before us, the controversy does not at all survive. No useful purpose shall be served by keeping the matter pending in the court. The contempt matter stands stop accordingly.
Item number 15.
May I please, Your Honor? My lord, the order dated 28/7/2022 passed in WPC number 17901 of 2022 has not been complied with. So I have filed one contempt application earlier. That was, my lord, disposed of.
All right, where is the order?
My lord, that order is page 9. The contempt application order is page 9. And
Not contempt the original order.
original order, my lord, I am sure. There are, my lord, some financial dues, my lord, pending against the government to.
No, you have not brought on record the order.
No, my lord. Sorry.
What kind of contempt application is it?
In earlier application, I have filed, all, but here, my lord, I have. Sorry.
Yes.
My friend may give me a copy of that first order. I will go through that.
Even give it.
My lord.
It's time is allowed for the state to report, seek instruction to learn it easily for the state of Orissa to seek instructions and report full compliance of this court's order, violation of which is being alleged in that application. So,
Item number 16.
My pleasure, Lordship. As the contempt petition has been filed against the General Manager, Orissa State Transport Road Corporation. And there is a clear violation of this order of this honorable court. And I have imposed the direction of this honorable court under Annexure 1 and running page 10 by the operating department. There is a direction. In view of the matter, this court is inclined to entertain the writ petition. Same is dismissed. Accordingly, this court direct the management to the petitioner to comply the order dated 4/4/2016 passed by the presiding officer, Labour Court, Bhubaneswar, ID miscation of 48 of 2015. And as per the page 10 last para, that's the direction of this honorable court members. The division bench of this one. That to comply the order 4/4/2016 as ID miscation of 48/2015. ID case number 48/2015 is a proceeding under section 33, which is a computation as per the award, the benefit as per the award, original award. Original award is a reinstatement and a compensation. First time a notice will go, it is corporate. Notice will go, my lord.
Notice.
Notice.
Item 17.
Please, your lordship. Petitioner approached this honorable court earlier. For which this honorable court under dated 23/11/23 disposal of petition, lordship may kind of glance to page 16. The para 4, the operating portion, my lord. Para 4, page 16, running page 16. In course of hearing, learning counsel for the petitioner state that petitioner already filed his objection before the opposite party number 1 under annexure 5. Pursuant to the notice such and such, same may be direct to consider within a stipulated time, to which learning counsel state has no objection.
Yes, it's fast content. I'll obtain instruction, also grant me some time. Yes.
Published.
For orders item number 18.
After becoming improper.
This was actually referred to the larger bench regarding maintainability of writ appeals in criminal matters. They have answered the reference, and thereafter while answering, they have said it that place it before the bench. So this can be closed in terms of that division bench or full bench order.
Full bench order.
That is a part of the records. We are giving a short note for convenience also, including the reference. The judgment is a part of the record at flag A. They have answered the reference.
Writ appeal is not maintainable in criminal cases.
This was prior to the Supreme Court judgments. Thereafter, Supreme Court has come up.
In civil matters also, our full bench decision is.
This was vis-a-vis criminal matters.
This is criminal.
For convenience, I have given a short note of 2 pages.
This is also reported in ILM.
This is reported. This judgment. For convenience, I have given a short note for your lordships.
This was referred to.
This matter itself was referred. And while answering the reference in paragraph 19, they said that writ appeal is not maintainable in paragraph 16 and 17. But in 19, they say that you place it before the regular bench. This has to be closed in terms
of reference being answered.
This intra-court appeal. Various intra-court appeal. The appellant you had challenge system style number. What was the challenge? Where is the memo of
what was challenged, my lords, would be reflected in the
WPCRL number 1966 of 2013.
Where is the appeal? Memo of appeal, which page?
WA is 122 of 2014. The again order of WPCRL Miller.
Had put to challenge an order dated 6/3/2014 passed by a single judge in WP bracket Tribunal number 1066 of 2016. 13. Where is that one?
1066 of 2013.
That is answer 3, page 30. Page 30.
Where is the reference? Where is the reference order?
Reference order, my lords, would find in the writ appeal order dated 11/9/2014. In the writ appeal order sheet, order dated 11/9/2014. Initially, an amicus was appointed on 28/2014.
11/9/2014.
11/9, the reference order.
When the question was on 11/9/2014, division bench of this court formulating following question had referred the matter to a full bench to answer the reference. The precise question which are answered and up to before the division bench of allowance. So the full bench of this court has answered the reference by a judgment dated 19/11/2015. 19/11/2015 in following terms. Paragraph 13.
13 to 16, my lord, 13 to 17. If my lord wants, I'll also give the SCC version of this. 13, they reflect, they take
Let us
note.
follow the order or order sheet as
My lord,
there in the-
my lord, I will.
the order in places. 13 is the only paragraph.
13 is, they refer to the conflicting views of this court and the Andhra Pradesh High Court in paragraph 13. Then my lords, 14, 15, 16 and 17.
That is read paragraph.
I'm just referring to
Yes,
You are reading SCC.
SCC online.
Please read the original order. We do have the original order.
Which I'm so sorry, my lords.
Page 10 of the original order. That is the
I don't
only
have the
paragraph.
original order.
Next. After having held as noted above, the full bench find that writ appeal was required to be dismissed as not maintainable. Next, review of the opinion, review of the answer to the reference. In view of the full court's answer to, in view of the answer by the full bench to the reference, the writ appeal is dismissed. That is not material. That's all.
The court's order paragraphs would be 11 to 14.
11 to 14.
13 is the main. 11.
14 because ultimately the conclusion is in.
11 to
Okay. You're all good. In the other matter, my lord wanted that rules for certified copies that is there in chapter 8 of the High Court rules. I didn't want to interrupt my lords then. Chapter 8, rule number 2 deals with certified copies and thereafter for a single. Chapter 8, procedure before admission.
Yeah.
Rule number 2, towards the end, it is there that it shall be accompanied by a certified copy of the judgment appeal.
procedure before admission.
My lords. Procedure before admission, then rule number 2, which begins with subject to Article 12. Every appeal, this is for latest patent. And under that rule 2, towards the end, that provision is there, it shall be accompanied with certified copy.
Where is certified copy?
Page 49, if your lordship is holding the OLR book, it's at page 49.
Just above
Page 49.
Rule 2, Sub-Rule 1 towards the end.
Last.
That is for letters patent. Similarly, for single judges also it is there. Well,
Item number 19.
we are all grateful.
May I please show? Your Lordship will find the affidavit of second copy according to the new format. So let it come next.
On the cassette
Yes,
of 19.
Your Lordship. Grateful.
Item 20.
My lord, I'm sorry that when yesterday the case was called, I could not appear. Even. My lord, I also by now know the mind of my lord about this case. I'm intimated. What I pray, my lord, that the CMPL may not be allowed, but give me some time. I'll see that the matter is complied. Everything can be settled. I'll see that the matter is settled.
That's what he said before the honorable single judge also. He filed a petition seeking 1 month time to comply the order of the honorable single judge. Then suddenly this writ appeal and all this syndrome for last 3 years. In the meantime, I only informed your lordships. I do not want to enter into that his daughter died, he could not give service. He himself is on bedridden condition.
Within a month, everything will be complied, my lord. I give my understanding.
So we can adjourn.
Yes, ma'am.
Business has jointly requested on behalf of the parties this matter of 1 month at the top of the list.
Yes.
And that senior undertakes that compliance. Well, this is what is the problem.
I'm a
The
lawyer, I
officer
have
there, office,
I'll see.
I know, I am only making a statement with a begging bargain. The officers sitting in that office of the insurance, they are very adamant. There is a parochial plea. I am compelled to say.
We will sternly deal with them on the next.
Yes.
Since some
Good gesture is coming from him.
senior counsel.
Minors. I know he is sincere. I know he is sincere. The officer behind there may be doing. He will do.
Item number 21.
There is a limitation and let's me turn to the input order. At page 77.
Order is at page 77.
My lord.
Input order is page 36 was relying the page 77 order.
Yes, my lord. Why I am drawing my lord's notice? The lord's must turn to page 77 first. Relying this order, my lord, then your lordship may turn to page 36, annexure 1.
No, page 77 is one order.
Yes, my lord. Relying
This
the
order under challenge.
no, my lord. This order was relied upon, and
Your Lordship, the input here, page 36, annexure 1.
Yes.
What has happened? Well, all these appeals were filed against that input order at I have shown at page 77. 3 appeals were filed, and those are dismissed on the ground of limitation. So I bring my Lord's notice first page 77. And all these matters were pending before the Honorable Apex Court. If Your Lordship will allow this matter pending till disposal of the Apex Court, or Your Lordship may dismiss it on the ground of limitation.
The common judgment is.
Yes, common judgment that is under challenge before the Honorable Apex Court. And all those matters were dismissed solely on the ground of limitation.
How much delay?
Here, my delay is 180 days.
No, but even if we dismiss your appeal.
Yes, ma'am. That's why I'm saying.
Just a minute. If we dismiss your appeal on the ground of limitation, and finally you succeed before the Supreme Court, then you have to follow what is finally laid down by the Supreme Court.
Yes, ma'am. That
in terms of the present order.
That I am submitting. Ma'am.
Notices have been issued.
In other cases, Your Lordship may see that I have given a similar case. Your Lordship has kept the matter pending till disposal of that matter before the Apex Court.
What's this? Appeal along with WA number 1135 of 2020. That's all?
Well, there, Your Lordship has kept.
We are not controlling it here.
Well,
we are just directing that this matter shall be listed along with that.
Well,
we make it clear that we have not considered for the present the appellant's prayer for condonation of it. Okay. But Mr. Counsel, even if that order is allowed to continue, we don't interfere with this order. Even then, your fate will depend on the decision by the Supreme Court.
The government filed a SLP challenging the order dated 10-10-23. 10-10-23. You will also kindly see the 10-10-23 order. For us, my learned friend not produced.
10-10-23.
My lord, that is on the ground of maintainability. You will also kindly see that order. That is same Harapriya Patra. So many cases they filed one appeal.
That is different. One appeal, all the orders cannot be challenged.
My lord. And that is Harapriya Patra case. That is Harapriya Patra case, this Honorable Court.
This is carried to Supreme Court.
Against this order, they went to Supreme Court.
No, this order is not under challenge. WPC OS number 2.
Yes.
Sir, whether this order is under challenge or not.
Yes, my lord. All the orders, writ appeals are filed and all the matters are prepared on will appeals court. A batch of
We are again putting the same question.
my lord.
Whether this WPC OSC number 2709 of 2016 is under challenge or not.
Yes, my lord.
There.
Here our challenge, this was dismissed. In writ appeal was challenge, number, my lord. Number.
That was dismissed.
Yes, ma'am. That
All
was,
the appeals have been dismissed.
yes, ma'am. That I am submitting, my lord. All the appeals are dismissed
On what ground?
on the ground of delay. And well, I'm telling you what is going to be the order of. Is covered by my lord's order, item 22. This is covered by my lord's order. That is, lordship can have a glance to my lord's order. That is Bindusagar Samantrai case. Appointment under rehabilitation assistance.
Rehabilitation assistance.
Yes. All right. And there is also delay. Your lordship can condone that delay and this.
Bindusagar, you have not gone.
Yes, yes. That is also pending.
You are still in Supreme Court.
Yes.
This case follows the Supreme Court. In our case, again, because that is consuming the arguments. Whether from the date of application or on the date of consideration, the law.
In all those cases, notice has been issued.
Item number 23.
Item number 23, my lord, on delay, notice was issued. The issue is also otherwise covered by my lord's orders. It relates to promotion. My lord knows the Joseph Barry case. That promotion, the 3 division bench 1 writ appeal court of this honorable court has already held.
Pending criminal case.
Pending criminal case cannot be promoted. No, not even ad hoc promotion. So, but the honorable single judge directed, I am just giving 2 orders for my lord's reference.
Criminal cases are pending.
Read it out.
Since 2012, and in a similar case, government implemented order, your lordship kindly see. Pick and choose basis, they are adopting pick and choose method.
No, they may be doing that, but we have to follow the law.
My lord, your lordship.
As has been laid down.
Mine.
What type of criminal case is pending?
Vigilance case, one.
Why for last 12 years?
My lord, our stand before this honorable court is government has no control on such vigilance proceedings, my lord. He is a party. He has not made out a single statement in the entire petition, my lord, as to how he tried to expedite such criminal proceedings. Not a one sentence, but the entire burden is shifted to the promotion giving authority, as if we are in fault in not considering the matter. There is a guideline in force, my lord. Because of this, we are not able to give you promotion. So that attributing that fault to the promotion giving authority, that because of I am suffering to 10 years, 8 years, vigilance proceeding is pending, you are not considering. But what steps you have taken? You are a party there.
So you are blaming the court or them?
No, my lord, no. I am blaming the respondent, my lord.
And you may be right in your submission that you are not to be blamed, the courts are to be blamed.
No, my lord, I don't say, my lord. The respondent has to say, my lord, he can file a case here, seeking direction for expedite of that trial. Why not? So many remedies are available. But question is, what? There is no demonstration, my lord, even a single line in the entire petition, my lord, will see as to how he has taken steps. And my lord, there are 3 decisions of this division bench of this honorable court.
2 division.
That yes, you cannot, promotion cannot be granted.
Well, 2 division bench order, by lord, your lordship separate order. Annex 6 also another division bench order to comply the guidelines of the department. Annex 6 in the writ appeal.
Latest one is 11/5/2023.
But two division bench.
The batch matter.
My lord, maybe latest judgment, but on same issue 2 different judgments.
No, there is no different judgment.
Annex 6 is judgment.
What is your case number? What is your case number?
WBC.
Criminal case.
Criminal case number. Year number 35, my lord. Year number 35. Tier number 35 over 2012.
Pending before?
Pending, you lordship kindly see, I have filed CRMC. Since the order of the court expedited the order. Is it wrong in saying?
What is the stage? Where is the matter pending?
Lordship kindly see that order, my lord. Thereafter, no action, no matter is pending, man.
No date.
So because of you, the matter is pending. This case was filed in 2012. And in 2020, you filed an application for quashing the entire proceeding.
Thereafter,
so you must have taken a plea before the trial court that since your application is pending, don't proceed. So did you file any such petition or not?
I will take instruction on the matter.
What instruction? You are delaying.
I will take instruction. I am not delaying. I will take instruction on the matter.
We know how the things are done. Why are you saying, why are you relying on this order?
You approach this court
My lord.
8 years after lodging of the FIR for quashing of the entire case. And you don't have the idea as to what is the stage of the criminal case.
I have a prayer.
Latest judgment of
Annexure 5, page 43. Is my lords in the writ appellate?
52, page 52.
Is my lord's order in the writ appellate? So I say that I am covered by this order, this judgment of my lords.
The question is posed.
My lords also, I have given the order. My lords have also.
This case.
Present intra-court appeal. The appellant has put to challenge an order of this court dated 22/7/2000. An order passed by a single judge of this court dated 22/7/2021.
Yeah, my lord. 8/9/23.
8/9, where is that?
8/9/23 is annexure 3. Page 20.
8/9/2023. Passed in WPC number 20344 of 2021, whereby the petitioner's writ petition came to be disposed of so the petitioner had approached, the appellant had approached this court seeking a direction to the opposite parties to grant him promotion to the post of Deputy Executive Engineer and then to Executive Engineer from the date with effect from which his immediate juniors had been granted such promotion. The noticing the fact that there was a criminal case pending against the appellant, comma, in the light of division bench decision of this court, that decision has not been taken note in this case. Has not been noted. Barik's case?
Joseph Barik.
Huh?
Joseph Barik.
There.
My lord.
That has been taken note of.
That has been taken note of.
Where?
My lord, in at paragraph 7. My lord, sir, in paragraph 5, my lord, sir, Honorable Single Judge has noted W805, my lord, got it? Paragraph 5, page 25. 805. This appeal has been filed by you. My lord. The Appellate State of Orissa. By the single judge has allowed the writ petition and directed the state of Odisha to grant promotion to the petitioner to the rank of executive engineer bracketed civil from the date of his his juniors and the batchmates got such promotion. So stop. While issuing the direction, the learned single judge observed that the promotion granted to the petitioner would be subject to the outcome of vigilance proceeding, which is pending in the court of learned additional special judge bracketed vigilance Cuttack in TR case number 35 of 2012. So stop. Learned single judge has placed reliance on a Supreme Court's decision in case of Union of India versus KV Janki Raman and others, reported in 1991, volume 4 SCC 109, and has held that irrespective of pendency of criminal case, the petitioner has continued to serve. The respondent has continued to serve, and mere pendency of criminal case cannot be taken as a ground to delay the promotion to the petitioner, nor the competent authority can withhold the recommendation for an indefinite period on the ground of adopting sealed cover procedure during the pendency of criminal proceeding. Stop. Next. Learned AGA arguing the appeal on behalf of the state has submitted that the learned single judge has not duly addressed the division bench decision of this court in case of State of Odisha
and another versus Joseph Barik, rendered in Barik, reported in 2023, bracketed Roman 2, ILR-CUT 361, wherein it has been specifically held that that a government servant has no right to be considered for promotion during the pendency of either departmental proceeding or criminal proceeding, or both. Full stop. He has submitted that the decision rendered by the learned single judge is in teeth of the law laid down by this court in case of Joseph Barik Supra. Full stop. Next, learned counsel appearing on behalf of the respondent per contra has submitted that merely on the ground of pendency of a criminal case, which is pending for last nearly 12 years, the petitioner, the respondent should not be denied his right to promotion to a higher post in accordance with the service rules. Stop. Next. So he has also submitted, he has brought before us an order of this court passed on an application filed by the respondent under section 482 of the CRPC for quashing of the entire criminal case. Which came to be dismissed by an order dated
Dismissing, not dismissed, my lord, lordship.
Indie.
Expeditious hearing by direction.
Where is that?
Lordship, final order, only one copy with me.
Which came to be disposed of by an order dated 5/4/2023 with authority to the petitioner to raise the points raised in the said application at appropriate stage of the case before the learned trial court. Stop. Apparently, the respondent approached this court nearly 8 years after registration of FIR against him under section 482 of the CRPC. Stop. Next. Be that as it may, in view of the law laid down by this court in case of Joseph Barik bracketed Supra, the impugned order cannot be sustained. The impugned order of the learned single judge directing consideration of the petitioner's promotion cannot be directing grant directing grant of promotion, not directing grant of promotion to the petitioner cannot be sustained. So, the impugned order dated 8/9/2023 is accordingly set aside. The appeal is allowed.
May I say one thing, Lordship, kind permission?
Appeal is allowed. So, it goes without saying that the petitioner's case for promotion shall be considered depending upon the outcome of the criminal case. So, the respondent, yes, what do you want?
There is a different division bench, another division bench order directing to consider promotion, ad hoc promotion. Two different division bench order. May I pray your Lordship, maybe refer to the larger bench so that matter.
Where is that division bench?
That is Annexure 6, page 57. If your Lordship will refer the larger matter will be settled.
There is no different order, my lord. That was taken note of in the letter.
May be taken up, but one division bench
of
one division
by the letter division bench.
All right.
One division bench will not, my lord, supersede another division bench, my lord. It's settled law of the Supreme Court. 5 judges bench, I will show, my lord. Tomorrow, your Lordship kindly adjourn the matter.
Let him show, my lord. There is no difference.
Bench held that one judgment, previous judgment will be valid.
Page 56.
Also by. Where is that? 56. Yes. So where was that decision considered in the division bench?
Annexure 6, page 57.
Page 57.
My lord. To the writ appeal.
No. This decision was, whether this decision was considered in case of Joseph Bari.
Yes, my lord.
Which paragraph?
And this case.
In Joseph Bari case, page 55 considered, my lord.
Page 54. Last paragraph.
That is State of Orissa versus Somnath Sahu.
Page 54, para 9.
Para 9, page 54, para 9.
Along with the Janki Raman case,
Right.
Somnath Sahu case was taken.
Yes.
And Anil Kumar Sethi case was also taken note of.
But one division bench will not supersede another division bench.
Learned counsel appealing on behalf of the respondent has also argued that the view taken by the division bench of this court in case of Joseph Barik is contrary to the view taken by another division bench decision in case of State of Odisha versus Anil Kumar Sethi, dated 26/4/2023, 4/2017 in WP bracketed C number 22393 of 2015. So stop. And State of Odisha versus Somnath Sahu, dated 5/10/2016 in WPC number 19909 of 2015. And there 15. So stop. There being conflicting views of the two division bench decisions of this court, conflicting views in the division bench decisions of this court, this court should consider referring the dispute to a larger bench. Refer the question to a larger bench as to whether an employee facing a criminal proceeding can be denied, as to whether denied consideration of his promotion during the pendency of the criminal case. Stop. Next. From this court's order, court judgment in case of Joseph Bari, we find that the coordinate bench decisions of this court in case of Anil Kumar Sethi bracketed Supra and Somnath Sahu bracketed Supra have been taken note of and considered before reaching a conclusion that a government servant did not have a right to be considered for promotion during the pendency either of a departmental proceeding or a criminal proceeding. So stop. We do not find the, as the said decisions have been taken into consideration by the division bench, we do not find it to be a case fit for a reference to a larger bench. Stop. Next. This appeal is accordingly allowed. Impugned order dated so and so is set aside. Stop. It goes without saying that the respondent shall be at liberty to take such steps as may be available to him under law for expediting the trial. We will see how the trial can be expedited.
Item number 24.
Lordships, there's a delay of 315 days, and Lordships have filed an application for condonation of delay as well. And Lordships, in fact, if Lordships would have a look at the application, my client suffers from medical conditions. She has diabetes, she has hypertension, osteoarthritis on both the knees, and she has bronchial asthma, as a result of which she could not come earlier for filing of the writ appeal. And there's a doctor's certificate also as well, Lordships, which certifies that she has been suffering from diabetes and all the medical conditions that I've just mentioned. That's an
Where is the order?
Lordships, the impugned order, Lordships, is at page 32.
Page?
32, Lordships. Lordships, in fact, my main grievance, Lordships, in the impugned order is that the learned single judge has come to a finding that she deserves to have the, Lordships, the compassionate allowance, which should have been sanctioned to her. And he also says that she is yet to get the benefit of the same. And the SP had in fact recommended for grant of the sanction, for grant of the compassionate allowance, which has not yet been granted to her. And Lordships, this is a most unfortunate case where the appellate has been running from pillar to post, Lordships, right from 2004 and 2005 when her husband expired.
Order is in your favor.
No,
Why have you challenged?
Lordships, I would come to that. Lordships, if Lordships, that's the reason I would just like to give a brief background to the case. Lordships, the appellant's husband has expired, Lordships, in 2005. Prior to that, there were disciplinary proceedings against him for which he's been dismissed from service. Lordships, she files an appeal, and the appeal was filed in 2005. Lordships, it's been almost 20 years now. The appeal has not yet been decided. However, the SP, in the appeal, he grants some kind of a sanction that she should be granted some allowance, some compassionate allowance. In 2006, 2007, Lordships, both the years he recommends for a grant of Lordships allowance, which has not yet been granted to her. She sends a representation in 2008. Lordships, that is the representation the single judge says that has to be now considered by the competent authority. Lordships, after so many years. This order is of 23rd March 2023.
No, where is the provision for compassionate allowance?
Lordships, that is what the SP has in fact granted. As per the rules that has been given, Lordships, because he was appointed with the police. And Lordships, the rules thereby say that
He was not in service as on the date of his death. So what benefit can he get?
Lordships, there has been a recommendation.
More than what you were entitled to.
If I could just take Lordships, with Lordships' permission, if I can take Lordships to page 34, where the single judge has himself admitted that she was.
The single judge cannot admit.
I would
single judge does not file counter affidavit or.
No, in fact, the single judge should have decided the matter on merits instead of.
We are there to decide.
That's the reason why I would want this honorable court to decide it on merits.
So your husband was dismissed when he died.
2005, Lordships.
5.
Yes, Lordships. Just a month after he's been dismissed from service.
Since you said 2015, therefore.
Dismissed from service 2004 and expired in 2005. And the appeal has immediately been filed by me, his wife. And Lordships, in 2006 and 2007, the SP has recommended, Lordships, they have in fact relied upon Rule 46(3) of the pension rules, Lordships.
What is that?
Lordships, I'll just.
And could she file an appeal?
I'm sorry?
Could she file an appeal, the wife of the employee?
She has filed an appeal. There has been no. Yes, she stepped into the. She stepped into the. The position of her husband, Lordships, to do so. But that has been pending, and that has not even been decided that she didn't have the locus or anything. That has also not been stated anywhere. Lordships,
you're relying on
Orissa, this is Orissa Civil Service Commutation of Pension Rules 1992. Lordships, I'm relying upon that rule, which talks about 46 is compassionate allowance. Would Lordships have that? Yes, Lordships. (46)(1)(a), if Lordships has it. May I, with Lordship's permission, read out?
Just a minute.
Yes.
Irrespective of your appeal, they should have considered this.
Yes, Lordships.
The proviso.
They should have. And what the single judge, Lordships, the reason why I was forced to come and appeal before this honorable court was, in the impugned order, the learned single judge says that she should have received that the compassionate the allowance, but however, remands the matter back to the competent authority to take a call on it. And on a representation which she had given in 2008, Lordships, after so many years. So, Lordships, once the single judge decides, so the single judge's order, Lordships, if I may be permitted, page 34, just one para, where I would show that the single judge erred in not deciding the matter when he's decided most of it. Para 6, page 34. Having learned counsel for the parties and taking into account the communications available at annexures 6 to 8, this court is of the view that instead of considering the appeal so filed against the order of dismissal, the authorities are prima facie satisfied that the compassionate allowance is required to be sanctioned in favor of the petitioner in terms of the provision mentioned in under Rule 46 of the OCS-CCA pension Rules 1992, but it is found that in spite of all such favorable recommendation, Lordship, this is important, it is found that in spite of all such favorable recommendation, the petitioner is yet to get the benefit of the same, and the grievance made by the petitioner.
So this is the best order which could have been passed.
No, but then again, they remanded back.
Yes.
And Lordships, it's been a year now.
Because the court cannot take a decision, which is to be taken by the administrative authority.
Lordship, this was an order of 23rd March 2023.
Point out to the police manual. So your dismissal for amounts to forfeiture of the entire past service.
Lordships, the 46 talks about special consideration. On special consideration, Lordships, because the family obviously would require.
That can be seen by the.
Lordships, in fact, just one more point, one more submission I would like to make. Lordship, this is an order of 23rd March 2023. The learned single judge had directed that the matter be taken up and the order be passed within 2 months. Lordships, it's been a year now, they have not done so.
The appellant's husband was a constable.
He was a constable in the police.
Was a constable
in Ganjam district.
Orissa police. Stop. He was dismissed from service consequent upon the findings in a departmental proceeding by an order passed on 9/12/2004 by a competent authority. So, he died on 3/1/2000. Sorry, he died on
3rd January 2005.
He was dismissed on 9/12/2004. He died on
3rd of January 2005.
3rd of January 2005. So, the appellant is said to have preferred an appeal against the order of dismissal in 2005 itself, which has not been decided. Stop. The appellant approached this court by filing a writ petition.
She had initially filed an OA before the SAT. After the abolition of the OA, Lordships, the matter was transferred to
approached the administrative tribunal by filing an original application, which came to be transferred to this court upon abolition of the tribunal, giving rise to WPC bracketed OAPC number 216 of 2014, which has been disposed of by an order dated 28/3/2023 with following observation, paragraph 6. Stop. Learned counsel appearing on behalf of the appellant has submitted that this court, taking into account admitted facts and circumstances instead of directing the opposite party number one to take a final decision, ought to have taken a final decision and directed the opposite parties to pay compassionate allowance in terms of the proviso to Rule 46 of the Odisha Pension Rules. 1992.
This is the Orissa Civil Service Commutation of Pension Rules.
She further submits that though the order was passed on 28/3/2023, till date, respondent number one has not opposite part till date the opposite party number one or respondent number one.
It's opposite party number one.
Respondent number one has not taken any decision, and the appellant is not getting any compassionate allowance, not getting compassionate allowance. Stop. Next. We, after having seen the impugned order passed by the learned single judge, we are of the considered view that following sound principles of judicial, legal principles on the scope of judicial review in a proceeding under Article 226 of the Constitution of India has directed the opposite party number one in the writ proceeding to take a decision upon the appellant's claim for payment of compassionate allowance in terms of the proviso to Rule 46 of the OCS CCA Pension Rules 1992. OCS stop. It is settled law that except in exceptional circumstances, the court does not take decisions which are required to be taken by the executive officials exercising power of judicial review. Stop. We do not find any merit in the contention raised on behalf of the appellate. Stop. Next. While disposing of the, in our opinion, the appeal has no merit, which is accordingly dismissed. Stop. Next. While dismissing the appeal, we express our concern over the grievance raised on behalf of the appellant that despite the direction of the learned single judge, no decision has been taken by respondent number one on the point of payment of compassionate allowance. Stop. It is hoped that a decision shall be taken in the light of this court's decision in the light of the order passed by the learned single judge, failing which the consequences shall follow. Yes.
Item number 25.
Obliged.
25.
This is regarding what?
But he has paid for your payment of awarded amount in a land acquisition proceeding. People also come to page 7, the prayer in the writ petition to direct the opposite parties to pay the compensation amount to the petitioners awarded in land acquisition case number of 1965 within a stipulated time, or in case the compensation amount awarded has been paid to the opposite parties 7 to 12 illegally and wrongfully, the same may be recovered. So there is a provision under the old act for recovery if it has been paid to a wrong person, 33, 31, 2 minutes proviso. So how the read will be minutes
There is no representation on behalf of the petitioner. This application is accordingly dismissed for non-prosecution.
Item 26.
Very favorable. I'm for the petitioner Workman. Workman is challenging the award of the labor court, my lord, under Annexure 8. Annexure 8 to the writ petition. In a reference case, my lord, under Annexure 3 is the reference order. Your lordship may go to page 15 of the writ petition. The reference schedule of reference is there. Whether the refusal of employment to Sri Narendra Kumar Naik, casual labor, with effect from 26/10/1985 by the management of horticulturalist Bhubaneswar is legal and or justified. If not, what relief the workman is entitled to? After the all exercise, my lord, under Annexure 8, last page, concluding paragraph, page 36, my lord. Conclusion paragraph. The labor court revised, reached in a conclusion, paragraph 9, after carefully examining the evidence available.
We cannot read it.
My lord?
We cannot read.
I am having a type copy. May I give it to you? We have already filed the type copy.
Oh, it is there. No, it is not there. Maybe there.
Hmm?
It is not there, no?
I am giving the copy, man.
It's not scanned.
Later we filed that is there. Your lordship may go to the conclusion paragraph, my lord. Running page 36 and internal page 8, my lord, paragraph 9. After carefully examining the evidence available on record, already tendered by the parties, the documents already rallied upon by the management and keeping in view of the settled position of law, my lord, I am of the view the workman is not entitled to any relief as prayed for. Both the above issues are answered accordingly. And paragraph 10, hence it is ordered that the refusal of employment to Sri Narendra Kumar Naik, casual laborer, with effect from 26/10/95 by the management of horticulturalist Bhubaneswar is legal and justified. In that view of the matter, the workman Sri Nayak is not entitled to any relief as prayed for. My lord, the entire exercise reached against the workman, my lord, but the admitted facts I have stated in my rejoinder. Admitted fact, my lord, the workman has worked from 15/6/1984 to 26/10/85 continuously, and as per their muster roll, they have paid. That is the admitted views, my lord, before the labor court. So what happened, my lord? Here I have, as per 25B, my lord, I have completed 240 days work. I have worked continuously. So the 25F has not been complied. 25G, other workmen are continued, but I was not allowed. In the edge, alleged that they are a scheme worker. The scheme was continued up to 90, my lord. But I was kicked out from service from 87, my lord. Sorry, 85, my lord. I am placing the failure report of the conciliation, my lord, that is under Annexure 2, running page 14, my lord, given by the conciliation officer. May I read it, my lord?
Just a minute.
That copy is not legible. Do you have extra copy? Legible copy you have?
No, my lord. Only I can read or on some other day.
Then it is very difficult for us.
My lord?
Very difficult. You can give typed copies.
Yes, my lord. Then it may be adjourned to some
As
other day.
requested on behalf of the petitioner, list this matter on 2 weeks so as to enable him to file typed copies of such documents which are not legible.
Annexure 2, my lord.
Whichever.
Item 47.
27, I am for the deceased workman's legal heir, my lord.
On behalf of Mr. Das, who is in appeal, the matter may kindly be taken up as a model.
No, but there are 2011 matters. 2006, 2002, 2000.
Listing of cases is a very problem here, my lord. Listing of cases is a very big problem here, my lord.
Why?
That's why the matters are delayed.
So we can take up old matters first then.
Yes, sir. Item 27, there are two writ petitions. The award is challenged by the management side and also from the workman side. In the meantime, the workman died, my lord. Legal heirs are before already substituted in both the cases.
As requested on behalf of the parties, list this matter on 2 weeks. Yes.
Item 28.
Item 28, Your Lordship, I am for the opposite part number 2, workman, Your Lordship. I pray for 1 week time to file the counter, Your Lordship.
Very good. So if you could not file your counter affidavit in last 11 years, 10 years, then how can you file counter? Why should you file counter affidavit now?
No, Your Lordship. Here, Your Lordship, in the first case, Your Lordship, I have instructed to appear till that I have not filed the Bhoklatnama, Your Lordship. I will file in the meantime.
In 14/11/2014,
my lord,
extra copy was directed to be served. Thereafter,
Your Lordship, now in the other cases, subsequently I have appeared in the year 2022, Your Lordship.
in 2014 itself, there was an order to serve a copy on you, and you were expected to respond to that.
Because
and you don't have the Vakalatnama.
My lord,
you have not filed Vakalatnama.
In the first case, I have not filed, Your Lordship.
Then you cannot stand up in that case.
In the other case, I have.
Other case, we will see. In the case in which you have not filed wakalatnama, we cannot hear you.
Your Lordship, after out of job, they are working daily laborer out of station, Your Lordship.
Let us see what is the case about. 29. I don't know what to mean.
Maybe, Your Lordship.
Just start.
Your Lordship, the order under Annexure 1, Annexure 2 as page 15 is under challenge. To the limited extent, Your Lordship, when under section 33(2)(b) application, it is observed that or finding that the domestic inquiry is conducted by the management is fair and proper.
Yes. Yes.
My pleasure. So, Lordship, here the limited issue, Lordship, Your Lordship has a glance to page number 17 of Annexure 2. The workman, in spite of sufficient of notice, did not appear before the learned authority below, hence he was set ex parte. And it was, and the last line, Your Lordship, the domestic inquiry conducted by the management and was fair and proper. It is a section 33(2)(b) application, Your Lordship. However, in the next page, Your Lordship, paragraph number 6, it has stated that since it has not and it causes any direct loss to the company, the punishment is higher, which is not permissible under section 33(2)(b) of the Industrial Dispute Act, Your Lordship. That is the sole ground, Your Lordship. We'll also have a glance to
What is 32(b)? Why are you 33(2)(b)?
Lordship, 33(2)(b) on the date of discharge or dismissal, an industrial dispute was pending before the Learned Labour Court, Lordship. So it was the pre-requirement simultaneously when you have to seek post facto approval from the management under section before the concerned authority where the dispute is pending. Under section 33(1), it was a pre-facto. Prior to dismissal, you have to take permission, Your Lordship. Under section 33(2)(b), it has to take post facto approval. Simultaneously, three things has to be made. Your Lordship has a glance to the proviso clause. First is there is a dismissal or discharge. Simultaneously, you have to file a seek approval under section 33(2)(b). Third is payment of wages under the statute. Subsequently, by various decisions, it has been announced that the fairness of the domestic inquiry and the victimization and unfair labor practice has to be seen. Your Lordship has a glance to
Tribunal has just held that in view of the nature of allegation against him, the punishment of dismissal was harsh. Some other punishment ought to have been imposed upon him. He had not given any call for a strike. He had just participated. He had remained absent because of the call given for strike. So therefore, the presiding officer has held that some other punishment should be imposed.
With due respect to Lordship, under section 33 to be of the IDEA Act, that is not permissible. Under your Lordship has a glance to section 11A. That is through a reference. It can be interpreted through a reference, your Lordship. Your Lordship has a glance to section 11A. Wherein, may I read your Lordship?
Yes.
Where an industrial dispute relating to discharge or dismissal of a workman has been referred to the labor court, tribunal or national tribunal for adjudication also. This is the important, your Lordship. Adjudication means under section 10(1) read with 12(5) of the Industrial Dispute Act, and that is on approach of the workman, your Lordship. Here is, this is my application. And as per the settled position of law, Lordship has a filed one judgment of our own High Court. Lordship has a glance. Okay. 1999, 2LR 515.
So according to you, this order is beyond jurisdiction.
Obliged, Lordship. Even if your Lordship,
All right. What is 33 to be?
33 to be is Lordship seeking approval, post facto approval, to avoid victimization or unfair labor practice. Suppose the industrial dispute is pending. I am the beneficiary, your Lordship. To avoid victimization or unfair labor practice, to just a check before the authority and to see whether payment has one.
Now, we are giving you an example.
My lord.
That if the management wants to dismiss an employee, before doing that, he is required to invoke section 33 to be.
No, Lordship.
No.
Simultaneously. Simultaneously, Lordship.
All right, simultaneously. So if that application is met, then what the presiding officer is expected to do?
Whether the 1 month payment has been made or not, whether simultaneously he has been terminated and the section 33 to be application has been filed or not, whether domestic inquiry is fair and proper or not, whether there is a case of victimization or unfair labor practice, though that is not under the statute of Lordship, that is the judgment made law, that it has to see whether victimization or unfair labor practice. Means the domestic inquiry is fair and proper or not. Once it is observed that the domestic inquiry is fair and proper, and there is a case of no victimization.
It's a case of victimization.
No, Lordship, there is no finding. Your Lordship has a glance.
May not be a finding. But we can see.
Lordship has a glance to.
Yes.
Page 17, your Lordship.
Yes.
It starts from since. Last 11 line, your Lordship.
Yes.
Since there is no challenge of the evidence of the management, the workman did not appear nor contested, your Lordship.
Yes.
Regarding the fairness of domestic inquiry, I am inclined to hold that the domestic inquiry was conducted observing the principles of natural justice, and the opportunity was given to the workman to defend the charge leveled against him. The report of the inquiry officer is based upon the evidence collected during inquiry and is nothing to find that any fault in report. Considering the matters have on record and discussion made above, I have no hesitation to hold that domestic inquiry is fair and proper. Even your Lordship, the Honorable Appellate Court, one judgment, your Lordship, under section 11 also, once it is observed that the domestic inquiry is fair and proper, it cannot touch the punishment, your Lordship.
It can.
Paragraph number 16, your Lordship, last part.
Yes.
Well, the Labour Code, paragraph number 16, your Lordship, had earlier held that inquiry was properly held and there is no violation of the principles of natural justice and that the findings were not perverse. The vitiating fact found by the Labour Court against the inquiry are erroneous and are liable to be set aside. if the inquiry is fair and proper, in absence of any allegation of victimization or unfair labor practice, the labor court has no power to interfere with the punishment imposed. Lordship, that is the vital. Here there is no allegation, Lordship. LOC will also my point of argument. LOC has a glance to page number 4 of our own High Court judgment, division bench judgment. LOC. This is also a power under section 11A. That is the reference case also. LOC has a glance to 1989, 1991, 2 OLR 515. Page 4 LOC. 4 lines only.
1999.
I have given the judgment. LOC.
Give the citation also.
1991, 2 OLR 515.
5-1.
5 LOC.
515.
I pass one.
Yes.
LOC has a glance to page number 4. The division bench LOC judgment.
Yes.
When the tribunal, LOC first line, when the tribunal gives or refuses to give permission, it does not adjudicate an industrial dispute.
Yes.
Thus, an industrial tribunal has no jurisdiction while deciding an application under section 33 of the ID Act to consider whether the punishment sought to be meted out by the employer to the workman is harsh or excessive, or to substitute another punishment or impose any conditions on the employer before requisite permission should not be granted. Whether the power of the industrial tribunal under section 10(1)(d) read with section 12(5) of the Act is quite extensive, and the main object of the tribunal is adjudicate of the dispute. The legislature by introducing section 11A of the Act now giving power to the tribunal to satisfy itself whether the misconduct alleged is proved or not. So under section 11A, it can be verified. Under section 33(2)(b), under the limited jurisdiction, it cannot be verified.
What cannot be verified?
The punishment, proportionate of the punishment.
See, the workman was not even appearing before the court.
My lord.
Before the labor court.
He was behind the custodial lordship.
He was behind
the custody, and some employees are abandoned from service. Due to
because of the management.
These people had opinion lordship. On the day of termination or dismissal, they are burnt alive to the head of the unit.
They are
burnt alive, the head of the unit, in front of the gate of the company. So some people, workmen have abandoned, and some were in custody lordship. 11 workmen were there. So nobody were appeared in spite of sufficient of notice.
All right, we'll say. You will the workman?
My lord.
Do you have a kalatama?
No, your lordship.
In this case?
No, your lordship.
Then you should not argue.
Other two cases, your lordship, I have already filed.
We'll hear you.
My lord.
We will hear you tomorrow. In other two cases.
My lord.
We have heard the submissions which have been advanced.
But so far as The finding of the.
Mr. Counsel, could not follow. Tomorrow
Oblige, Your Lordship.
you reply to what?
So one more judgment of the Honorable Single Judge, because initially the Industrial Dispute Act matters were dealt by the division bench matters. Subsequently, it had dealt by the Honorable Single Judge matters. One more judgment also in support my case. I'm marking Your Lordship paragraph.
All right.
have posted to be heard today at 2 p.m. I have informed my Lord Senior and also the Lord Counsel for the opposite parties, my Lord. My Lord, may kindly allow us 15 days time, my Lord, for further examination of the law. Because, my Lord's, it needs further examination because, my Lords, for the direction, my Lords had given us on the very first day to examine the validity of the act. So
we will also examine, my Lord, because yesterday only I received the copy of the writ appeal.
One of the questions, the constitutional source of
that municipal.
Yes.
That
how that can happen?
Yes. That
The question to be written.
Yes, it's a very interesting question, Mal.
We will see.
Needs good deliberation. You will assist your lordship.
As jointly requested on behalf of the parties, including Mr. Parijal and Advocate General, to miss this matter on 2 weeks. 2 weeks?
Can it be 3 weeks?
Whatever is convenient to both the sides.
3 weeks.
First March. March around April first week. April first week. April first week. The holidays are.
3 weeks to be taken up at 2 p.m.
Bless.
Item 29. 29, I am appearing for the petitioner, my lord.
Yes.
My lords, you can see the last order.
order number 30. Yes.
This is what?
The Lordship directed to produce documents on the latest position of the case by way of affidavit. I am producing today, my lord. I have sought the copy on the other side.
You want us to see the order dated?
Order number 30, 6/12/23.
Yes. Latest position of which case? No, what is this? Learned Counsel is directed to produce document on the latest position of the case. Which case?
Well, this case relates to where Mahanadi coalfield is digging coal. A PIL was filed that the coal is being dug in a place dangerous to the villagers. Their stay was refused. On the very first day, so Lordship will kindly see, order dated, order 31/2015, stay was refused. Nobody was appearing in the case. For that reason, the Honorable Court directed, what is the present position? You file an affidavit.
Present position of what?
Relating to mining activities in those areas.
Not regarding any case.
No, mining activities.
Mining activities.
Yes. We have filed the reports from the various authorities along with this, and statutory clearances we have been granted in our favor. We have filed that. Both environmental clearance as well as pollution control.
You are representing whom?
Yes, I am Mahanadi Coalfield.
And who is for the petitioner?
I am for the petitioner, my lord. I am appearing for the petitioner.
Yes, what do you want? You must not have joined the bar when the writ petition was filed.
Yes, no.
You must not have joined the bar when the writ petition was filed. When did you join?
We have filed our Voklarnama 2016 million.
2016. And this writ petition was filed in 2014. All right.
You want a brief as transport to my senior later on.
All right.
No. Today I have received the affidavit, your lordship kindly.
No, but what is the public interest?
Public interest means the petitioner filed when the MCL is taking the mining operation near a village due to heavy blasting and damage to roads and the ponds and school area. The disturbance was created without any rehabilitation. They are doing that. On that ground, the writ petition was PL was filed.
So what is the stand of the estate?
Because they are the, we are not, because it's quite under the Central Act. So
Union of
it is
India.
no way affected. They are MCL will do all these things.
We have taken,
There is also, it's all against the MCL, it's nothing against the state.
we have taken all precautions, my lords. And the case which has been filed by the person, today's affidavit I have disclosed, he is an employee of the MCL. For some disciplinary proceeding has been initiated against him. And for that reason, he has done all these things. I had never disclosed that earlier. Today, I have filed the details that he is an ex-employee, he is created with all this.
No, but the land has been, it has been taken over by Mahanadi Coalfield.
Yes, ma'am.
Yes, ma'am.
And therefore you have no role to play.
No, I'm not saying that.
So you are not concerned with what is happening with the citizens of living in the
No, I'm not saying that. There is only prayer against the MCL. There is no specific prayer.
Here,
But no, state has got
public
a role.
interest litigation, you should not take this stand. We don't know, we are not commenting upon the merits of the case.
Absolutely right. State has a major role in it.
Yes, wherever.
Correct.
When the residents,
sensitive to these issues.
yes, so it is not that the state has no role to play. May not have role to play. May have role.
Why I said all the prayers will also see is against the MCL, not against the state. That was
Even if it is against them. So yes, so if we find that you lack bona fide, then we will be imposing cost also.
Lordship kindly allow me 15 days time. Today I received the affidavit. We will take instruction from the petitioner.
But take that instruction also.
Yes, ma'am.
That if the court opines that the petitioner lacked bona fide, then he should be ready to pay cost.
Oh, yes.
All right. As requested, an affidavit has, when did you file? You're filing? File it in the registry.
We'll file it. I'll do it.
And senior counsel appearing on behalf of Mahanadi Coalfield Limited has stated before this court that an affidavit in the light of this court's order dated 6/12/2023 is in the process of being filed today in the registry. So a copy of the said affidavit shall be served upon learned counsel for
I have received them.
has been served upon learned counsel for
Also, I'm giving a copy to the state also.
for the petitioner and the estate. So has requested on behalf of the petitioner to list this case on 2 weeks. So the court makes it clear that if it is found that the petitioner lacks bona fide in filing the present writ petition in the nature of public interest litigation, the court will consider imposition of exemplary cost.
Item number 30.
Item 30, my lord, I am for the employer, my lord. I'm for the employer, my lord. On behalf of Mr. Mahapatra, my lord, on the last occasion, I have taken time for filing of the additional affidavit, my lord, regarding the further developments. Due to the illness of my learned senior, I couldn't file the affidavit, same affidavit. My lord, 1 week time.
Take sufficient time. Every time.
No, my lord, for further 1 week time may be given to file the.
By way of last window.
By 2 weeks.
1 week further time is allowed for. You are?
I am for the employer, my lord. MR Pradhan. MR Pradhan.
OP number 2.
For. Is allowed for OP number 2 to file. File affidavit. So list this case on. 2 weeks.
Item 32. Item number 32, sir.
Yes.
It's a batch of 3 doubles, my lord. In one case, I have also filed a IF for substitution. Other.
How many cases are there?
6 cases are there. 3 cases have been filed by Odisha Mining Workers, Odisha Mining Corporation, and 3 cases have been filed by state.
Order is same.
Order is same, madam.
Let us see the order first.
Well.
You are pressing 585 or 580?
Hello.
607.
I am pressing 584 of 2022, man.
584. Second one. Second one.
Yes. Second one, man. Order is at Annex 6, page 241. In this case, I have also prepared a short dead chart and I have submitted it.
Let us see the judgment first.
Hello.
The judgment is dated 23/12/2021.
8/12 to yes, ma'am. 23/12/2021, page 245.
Yeah.
May I read my? Sir.
Yes. What has been held?
Well,
what has been held in this case?
Honorable Single Judge directed to extend the benefit of pension, holding that as if state government has approved the pension scheme. The lawsuit turned to para 45 of the judgment. Relying the lawsuit turned para 43 and 44, relying the judgment of Indra Sani and Uma Devi, the Honorable Court in para 45 held that In
Paragraph?
45, my lord, page 319, my lord.
Yes.
In view of the law laid down by the apex court and by applying the same to the present context, since similarly situated PSUs and such as OPGC and OHPC having come within the gold category have extended pensionary benefit to their employees, non-extension of such benefit to the similarly situated PSUs like OMC Limited, even though as a matter of principle the state government has approved the same, which has received the concurrence of the finance department, amounts to violation of Article 14 of the Constitution of India. As the equality is the basic feature of the Constitution, and the concept of Article 14 was interpreted by the Supreme Court as a concept of equality, confined to the aspects of discrimination and a classification. This court is of the considered view that in the order impugned dated 28/4/2014, which has been passed while complying with the order dated 8/10/2012, passed in WPC number 19405 of 2009, this basic principle have been lost sight of. Therefore, the order impugned dated 28/2014 in Annexure 9 cannot sustain in the eye of law, and accordingly the same is liable to be quashed, and he is hereby quashed. This court directs the opposite parties to reconsider the extension of pensionary benefit as per the pension scheme approved by the state government and concurred by the finance department in letter dated 5/10/91 in Annexure 4 as expeditiously as possible, preferred within a period of 4 months from the date of communication of the judgment.
Yes.
I'll bring my lord's notice to first case, which is the second round of litigation, my lord. Lord's turn to page 99. I have submitted a date check, my lord. May I place that date check?
Where is that?
I have submitted it on 22.
Yes.
By a compilation, my lord.
Yes. Yes.
Hello. 6/7/1961. Odisha Mining Corporation Limited, a government of Odisha undertaking governed under the Employees Provident Fund and Miscellaneous Provisions Act 1952, applied for exemption from the purview of Employees Provident Fund Scheme 1952 under Section 71A of the Act. 6/12/1982. Regional Provident Fund Commissioner recommended the case of OMC.
Yes. Employee Provident Fund. Yes.
My Regional Provident Fund Commission recommended the case of OMC Limited for exemption under Section 17(1) of the EPF and MP Act for the application of OMC Staff Provident Fund rules for the employees of OMC Limited. 1/6/1985. State government in exercise of.
Give a copy at least to have a.
No,
I've already subscribed the agreement.
My learned friend is searching for a copy. I have solved it.
No.
All right. Make your submission.
My one copy is with me. I am serving a copy. Upon this, 1/6/1985. State government in exercise of the power conferred by Section 17(1) of the EPF and MP Act 1952 exempted the OMC Limited from operation of EPF scheme 1952. 25/3/89. The Board of Directors in a 26/8 meeting decided and agreed in principle for the proposal for introduction of pension scheme for employees of the corporation at par with the state government employees with effect from 1/4/89. The board consists a committee consisting of the chairman, managing director, joint secretary, finance department, and secretary, financial advisor of OMC Limited to examine and submit a report in the matter to the board for taking final decision. 25/6/1991. The board of directors of OMC Limited in its 282nd meeting approved the proposal for introduction of the pension scheme for the employees of the corporation subject to approval of the state government and the Central Provident Fund Commissioner. The said pension scheme was named as Odisha Mining Corporation Limited Employees Pension Rules 1991, which shall come into force with effect from 1/4/1989. 5/10/1991. State government approved the pension scheme for the employees of OMC Limited with effect from 1/4/89, subject to modification of item number 6 of the draft rules to the effect that the age of superannuation of the employees of the corporation shall be 58 years, except in case of class 4 employees where it is 60 years. 12/3/1992. OMC management submitted a proposal to the Central Provident Fund Commission through the Regional Provident Fund Commission of Odisha for grant of operation for exemption for operation of the pension scheme in lieu of the contributory provident fund. 21/4/1992. The Central Provident Fund Commissioner did not grant exemption as the pension scheme is not in conformity with the requirement for operating the pension scheme. The Central Provident Department directed the OMC management to enter.
Which date you are reading?
Madam, page 3, 21/4/1992.
No, 21/4/1992.
My lord.
Could not be obtained.
My lord.
Under 17(1)(c). What is that?
The lordship. At page 3 of my date chart.
No. Where is that in the act?
21/4/92.
92.
Against that, you have stated exemption under section 71C.
So what is 17(1)(c)?
EPF Act.
Where is that? What is that provision we want to see?
That act.
That act, from that act, please read what is that provision.
Yes. 70 power to exempt.
That is 17.
17.
Where is 17(1)(c)?
17(1)(c).
The capital C.
My lord.
Capital C.
My lord.
One capital C.
My lord.
Oh, that is. You have wrongly mentioned in your.
Sorry, my lord. That is typo.
All right.
The board constituted 21/4/92. I am again reading now. The Central Provident.
That is 1C. Capital. Yes.
The Central Provident Fund Commissioner did not grant exemption as the pension scheme is not in conformity with the requirement for operating the pension scheme. The Central Provident Fund Department directed the OMC management to enter into a scheme of insurance with the LIC. 16/11/1995, Employees Pension Scheme 1995 was notified under the EPF Act. 33/2000, Board of Directors OMC Limited in 321st meeting decided for introduction of a pension scheme after getting approval from all competent authorities. 31/3/2003, OMC management submitted a proposal before the EPF Commissioner for grant of exemption under Section 17(1)(a) of the Act from the EPF Pension Scheme 1995. 26/3/2003. The proposal for grant of exemption for Employees Pension Scheme 1995 was rejected by the RPF Commissioner. 38/2004, OMC Board in its 346th meeting decided to form a core committee of the board to examine the issue and submit a comprehensive proposal to the board for extension of pension scheme. 23/3/2006, the board in its 350th meeting approved the scheme in the name of OMC Retirement Benefit Scheme for its implementation after obtaining approval of the state government. 7/9/2009, the board in its 373rd meeting decided that the scheme does not seem to be rational for the long-term sustainability and profitability of the corporation. On 10/2/2011, one Padmanabh Senapati and other employees of the corporation filed a writ petition before this honorable court in WPC number 9208 of 2011, which were disposed of directing the MD of OMC Limited to consider and dispose of the referent.
Oh, just a minute.
Details. Top
Yeah.
10 to 2011. Padmanabha Senapati and other employees of the corporation filed a writ petition before this honorable court in WPC number 928 of 2011, which were disposed of directing the MD of OMC Limited to consider and dispose of the representation within a period of 3 months in accordance with law. 25/2011. In compliance to the direction of this honorable court, the MD OMC rejected the representation for implementation of the pension scheme. 1/8/2012. Chairman and MD requested the Principal Secretary to Government Steel and Mine to accord approval of pensionary benefit to the employees of for implementation of OMC Limited following the rules and procedure of OCS pension rules. 16/1/2013. The Board of Directors OMC in its 396th meeting approved the modified pension scheme of 91 for implementation of the same with effect from 1/4/2012, covering the employees retired after 1/4/89 and for the employees who have joined in the corporation before 1/1/2005. 8/10/2012. Some employees of the OMC approved the Honorable Court in WPC number 19405 of 2009, which were disposed of with a direction to take a decision in terms of the request made by the MD within a period of 4 months. 5/2013. The Board of Directors in its 397th meeting decided to adopt the pension scheme for their employees. 7/9/2013. A meeting was convened under the chairmanship of Additional Chief Secretary, Finance Department, wherein it was decided that pension provision proposed to be made applicable to the OMC employees of OMC Limited has no longer been worked in central as well as PSUs. 28/10/2013. The proposal of OMC was not accepted by the Finance Department. 28/4/2000. The proposal was rejected by the Steel and Mines Department. 27/3/2017. P Department issued a circular with regard to one-time payment of financial to its retiring employees. 21/1/2000. Board of OMC in its meeting approved OMC employee superannuation scheme. 29/1/2009. Then it was challenged before my lords. The Honorable Single Judge allowed that. Then I will come to that judgment. Lord Smith, that was the first judgment of Honorable Single Judge is at page 99.
Yes.
May I draw my lord's notice? Page 122. Para 17.
Page
122 of my brief, my lord.
Your writ
122
of writ appeal.
of writ appeal.
Oh, page Annex 3, page 99.
It starts from page 99. I am drawing my lord's notice from paragraph 17. This was the order dated, my lordship, looking at that order dated 29/1/2019 order.
Paragraph 17.
My lord.
When the matter stood thus.
Yes, my lord.
When the matter stood thus, on 1/8/2012, the chairman cum managing director wrote a letter to the principal secretary of the Government Steel and Mines Department requesting for extension of pensionary benefits to the employees of the OMC Limited. The relevant part of the letter is extracted hereunder. The government in V department has categorized the state public sector undertaking enterprises filed letter number so-and-so Bhubaneswar dated 2012-2011, copy enclosed. OMC has been placed in gold category along with YPGC, that will be OPGC, OHPC and IDCO. The P department is also contemplating for implementation of a uniform pension scheme for the employees of the above PSUs. MS Deloitte Bhubaneswar has also been entrusted with the task of conducting a study of the existing pension scheme for them, develop a uniform pension scheme and submit the same to the department with 30 days from 25/5/2012. As the time is already over, MS Deloitte might have submitted its report to the government. However, now the government has extended the pensionary benefit to the employees of OHPC, one of the gold category PSU from the date of incorporation of OHPC, that is 1/1996, by letter number 5549 Bhubaneswar dated 11/7/2012. As OMC has also been categorized as gold category PSU fulfilling the prescribed criteria norms, implementation of similar pension scheme for the employees of OMC may be considered in accordance with the rules and the procedures of OCS pension rules.
So this is the order which was under challenge.
No, this was earlier challenged before my lord.
Yes, this was the order which was under challenge before the division bench again.
Yes, my lord.
When whereafter the matter was remanded back
with certain directions.
Certain observations.
Certain observation and yes, ma'am. Sorry, ma'am. Certain that what are the observation? I'll draw my lords that observation is para 27 of the second order. The read order part in that read appeal.
Page.
Ma'am. Page 129.
Yes.
Well, I place only the observation of the honorable division bench. Well, let me turn to paragraph 27. Before that, my lord, before that observation, I'll draw my lord's notice to para 20. I am you also can get it from page 135.
Yes.
The reasons that weighed with the learned single judge in issuing the above direction could be summarized as under. OMC is a stable PSU in the state and has been making profits continuously since 1976. The board of directors of OMC had already recommended the introduction of a pension scheme. The Steel and Mines Department Government of Odisha had approved the scheme and the Finance Department had also convened its concurrence. However, for reasons best known to the authorities, the said decision was not implemented. After the pay scale revision in 1989, a resolution was passed by the Public Enterprise Department on 16th August 1995, reiterating the recommendation that such PSUs should formulate suitable pension scheme, but it was stated that existing employees may be asked to exercise their option either for continuance under the existing CPF scheme or come over to the pension scheme to be divided by the management. Since this recommendation was general in nature, not specific to OMC, it would have no effect on the earlier decision dated 5th October 1991 of the Steel and Mines Department approving the OMC proposal for introduction of a pension scheme. Since OPGC and OHPC have also been categorized as gold category PSUs and have introduced a pension scheme for their employees, the denial of similar pension scheme to OMC was discriminatory. The impune order dated 28th April 2014 declining to extend the pension benefit to the employees of OMC was arbitrary and violative of Article 14 of the Constitution. Accordingly, the impune order dated 28th April 2014 was quashed and direction was issued to the present appellant to reconsider the extension of pensionary benefit as per the earlier approval dated 5th October 1991 as expeditiously as possible. Then, my lord, I'll bring my lord's notice paragraph 27.
Page 139. May I read, madam?
Yes.
The above submissions have been considered. Indeed, the ratio of the judgment of the learned single judge turns on a single ground, that is violation of Article 14 of the Constitution. This is premised on employees OMC being treated on par with those two other PSUs, that is OPC and OPGC, in the matter of pensionary benefit. The learned single judge did not examine any other ground as has been urged by the contesting respondents. In other words, the intrinsic merit of the proposal of the management of OMC made way back in 1991 for introduction of a pension scheme was not examined by the learned single judge while issuing a mandamus to the appellate to reconsider the introduction of a pension scheme of the retired employees of OMC. The court finds that OPGC employees in fact have no pensionary scheme governing them. The clarification issued by the Department of PE Government of Odisha makes it clear that they were entitled only to a lump sum payment equivalent to 6 months' salary at the time of retirement. This crucial information was not considered by the learned single judge, possible because it was not placed before him. As far as OHPC is concerned, the history of its corporation and the circumstances under which erstwhile employees of the government of Odisha or the OACB were either redeployed to it or deputed or transferred to it makes OHPC very different from OMC. This was the reason behind OHPC extending pensionary benefit to all its employees subject to certain stipulations. This was in nature of continuation of the benefit they could have otherwise enjoyed had they continued as employees of government of Odisha or the OACB. The circumstances attending the employment of the contesting respondents in OMC are quite different. They were directly employed by the OMC itself. Absent a pension scheme at the time of their employment, they cannot claim any vested right to such pension on the basis that they were on par with the employees of OHPC or OPGs. Therefore, the court is not satisfied that contesting respondents have made out a case for the applicability of Article 14 of the Constitution vis-a-vis the pensionary benefits enjoyed by the employees of OHPC. Consequently, the court is unable to agree with the conclusion of the learned single judge in the impugned order dated the decision dated 28th April 2014.
So the division bench was of the view that Article 14 could not be invoked.
Yes, ma'am.
To grant them pension, treating the employees at par with the employees of other corporations, because those are other corporations.
Yes.
And the employees of those corporations are entitled to benefits under the scheme of that corporation.
Ma'am.
That is the
and in para 31, ma'am, para 32. Consequently, while setting aside the judgment of the learned single judge dated 29 January 2000 for the affirmative, this court restores the writ petition to the file of learned single judge for a fresh condition on grounds other than the ground already examined by the learned single judge. It is clarified that this court has expressed opinion on the basis of so and so. The writ petition shall now be listed before the appellant shall file not later than 2 weeks prior to the affidavit and all documents which according to it are relevant for the issues arising for a consideration the said writ petition with advance copy to the counsel for the writ who shall file their response thereto by the 1st August 2021. It is made that so then in compliance to that direction we filed an affidavit. That affidavit was filed.
that was rejected.
Yes.
All right.
That
Why was that rejected?
That was rejected that we have not filed earlier.
Oh, is that the reason? Is it an admitted position?
Yes, well, that I have annexed that order. Else you can get it from
Page 241.
page 241, ma'am.
Yes. Yes.
Our affidavit was rejected. Then my lordship has seen that judgment at post 243. After that, judgment was pronounced on 23/12/2021.
No, but this is the sole ground available to you then.
Yes. My lordship had directed to file an affidavit, and in time we have filed that affidavit, not that beyond that. We have filed that affidavit on 14/7/2021.
Who is appearing? That is the sole ground.
Lord, I am appearing for the Federation, my lord. My learned senior friend is appearing for the private parties. My lord, here, the basic question, how is the state government in Malad agreed?
We will not go into that
Lordship,
because the coordinate bench had earlier decided the matter and had requested the learned single judge to consider other aspects with her liberty to the appellants to file an affidavit. That affidavit was rejected on the ground that those documents were not produced in the earlier proceeding. That was the observation made by the.
But with that, as far as that is concerned, this was the observation, so I cannot improve over that, Palad. But what I have about this respect, Palad. State government, Palad, this
we will not go into that.
Is it, Palad? Is it that state government is a party aggrieved to file a writ appeal? This concerns Orissa Mining Corporation, Malad, which is 100% state, not the shareholding is of the state government. The Lordship knows, Malad. It was a corporation under Section 617 of the Companies Act 1956. If it is a corporation, doesn't matter who is the shareholder. It is an independent entity.
Maybe,
Well,
whatever.
Well, what I'm saying, well, that's 2-3 sentences, Malad. The corporation, Malad, as a legal entity, Malad, as an independent entity of its own, the state government having no control over the management, Malad, Malad passes a resolution for implementation of a scheme, pension scheme. That pension scheme was approved, though not required, Malad, by the state government in the finance department. And because there was a delay, Malad, then there was another letter by the Orissa Mining Corporation chairman, which was read out by my learned friend, wherein the Orissa Mining Corporation chairman writes that the corporation stands in the same footing as of other public sector undertaking. So why should the benefit which ought to have been granted from 1991 should not be granted? Malad, in what state government is not suffering financially, the finance is not coming from the state. The entire corpus is from the contribution, Malad, which the employees have received from the government, from the mining corporation, and mining corporation making some Malad funding for the corpus. State government is nowhere affected, not aggrieved. If the state government is not aggrieved, then how is the appeal maintainable? There are 2 judgments I will cite of the Honorable Supreme Court. But 1998 judgments, Malad.
No, but whatever submission you are making.
This judgment takes care of, Malad.
The whole
question. Not the steel. Malad, this is volume 92, 1998 company cases. Lordship, may kindly come to page 128 in this judgment.
Page?
Not page 128.
Yes.
Coming to the merits of the case, we accept the contention of the learned counsel for the appellant that the High Court went wrong in holding that SAIL was the Department of the Union of India. In Dr. S.L. Agarwal versus so-and-so, AIR 1970 Supreme Court, a constitutional bench of this court, while considering a similar question, held as follows. We must therefore hold that the corporation, which is Hindustan Steel Limited, in this case is not a department of the government, nor are the servants of it holding post under the state. It has its independent existence and by law relating to corporations, it is distinct even from its members. But thereafter, my lord, it is contended by the Attorney General that since the appellant companies are wholly owned by the Government of India, the lands and buildings owned by the companies cannot be subjected to the property tax. The short answer to this contention is that even though the entire state capital of the appellant company...
Mr. Das, you can take this stand, but you will have to take this stand before appropriate forum in appropriate proceeding.
Well, yes, I'm out on ballot.
In no circumstance we can deviate from the observations made by a coordinate bench of the court.
But
binding.
Yes, now coming to my lord's query, my lord, straight to ballot. The judgment was delivered of the Honorable Single Judge on 29th of January 2019 ballot. When the matter came up before the earlier division bench ballot, then the document was sought to be introduced before this Honorable Court, which is 6 months thereafter, which saw the light of the day, my lord. Your Lordship knows the basic, my lord, the concept with regard to interference in the writ appeal, my lord. But it has been, my lord, it is a court of correction to correct its...
You could have challenged that order.
Well, that particular aspect.
You could have challenged the decision of the revision bench.
Well, that I filed a review application. I filed a review application by stating in the review application that other than Article 14 part, the Honorable Single Judge has dealt with all other aspects which had been left open by the division bench.
What happened to review?
The review application is dismissed on the ground. You raised the point before the Single Judge.
All right.
So
you could have the only apparent error,
yes,
which appears to have been committed by the learned Single Judge is that he rejected the affidavit.
Now I will not go back to that. But your Lordship's jurisdiction in the appellate style ballot is to correct if an error has been committed.
Therefore, according to you, the judgment of the coordinate bench was incorrect. It went beyond the jurisdiction.
What the division bench said, Ballard, Lordship kindly, hear what my learned friend read out.
We are not here to comment upon the decision of the division bench that is binding on all of us.
Now, let me take away the Article 14 part, Ballard, from the entire purview, Ballard. Now supposing Article 14 part has been dealt with by the Honorable Division before and has been held against. What has been held that other than Article 14, the learned Single Judge has not gone into any aspect. What the learned Single Judge...
Mr. Das, you are criticizing the decision of...
No, I am not criticizing, Malad.
And this criticism we cannot entertain.
With due respect, Malad, it's not a criticism, Malad.
Yes, you are criticizing.
No, I'm just...
Criticizing means you are saying that this ought not to have been done by the revision bench. We cannot go into that.
That is what has been reflected by the Honorable Single Judge in the... What you may just see, Malad. What I'm saying is a replication of what the Honorable Single Judge held, Malad.
Learned Single Judge cannot comment upon the... what was decided.
Only just seize that portion, Malad.
Very difficult.
Well, just seize that portion, Malad. At page 299.
So again, remark.
Well, Lakshmi just sees to page 299, paragraph 26. On perusal of the aforementioned paragraphs, it is made clear that while disposing of the writ appeals...
Mr. Das, we were refraining from making this observation. We are saying there is something called judicial discipline. So if there is some order passed by any, it's not a higher court, but of larger strength, then that is binding. And that could not have been ignored. And it has been rejected. We are of the view that possibly learned Single Judge missed that part of the observation made by the division bench.
But let me go to that part of the observation of the division bench, Palad. What is the observation about, Palad? when the division bench requested restored the file to the Honorable Single Judge's Appellate. Well, let me go to that portion. What has been observed by the Honorable Division Bench? Get the page open. No, this is single judge. The division bench is order. Articles. Yes. Lordship, see page 141, my lord. Paragraph 32, my lord. Lordship with me, my lord?
Yes.
Consequently, while setting aside the impugned judgment of the learned single judge of 29th January 2019, for the aforementioned reasons, this court restores the writ petition to the file of the learned single judge for a fresh consideration on the grounds other than the ground already examined by the learned single judge. Similar the ground, that means which have already been examined. Those aspects remain as such. They are not touched by it. Then thereafter, it is clarified that this court has expressed no opinion on the merits on other grounds urged in the writ petition, and leaves the contentions of the contesting respondents herein, as well as the contentions of the present appellant in opposition thereto, open to be urged before the learned single judge in accordance with law. Malad, with due respect, Malad, nothing has been left open. Everything was answered by the Honorable Single Judge.
Again, there you are.
No, that is what has been reflected by the Honorable Single Judge in the impugned judgment.
According to you, the matter ought not to have been remanded.
Well, in fact,
which you cannot say.
If I not rely upon the Honorable Supreme Court judgment in a writ appeal, in the appellate stage ballot, remand is not permissible under law.
Mister, how can you make
that? I cannot make that now. Now my wings are clipped. I know, Milan.
We understand.
Yes, my wings are clipped.
And then see the order passed by the learned single judge while rejecting the affidavit.
And
the single judge reports that the court is not required to see any document extraneous to the proceedings.
Prior to Malad, what the learned single judge made, Malad, any document which came into existence or which were not before the learned single judge when the matter was being argued.
So therefore, that was the observation made by the division bench.
But then para 33, Malad, the writ petition shall have the appellant shall file not less than 2 weeks prior to that date affidavit and documents which according to it are relevant for the issues arising for consideration in the writ petition with advance copies. So it means, my lad, relevant, that means relevant prior to, my lad, the filing of the counter, delivery of the judgment. It is not certainly a period after the judgment was delivered. They cannot go on improving the case. That is what the Supreme Court says, Ballad, an action at law is not a game of chess. You can't go on prevaricating the stand. The stand taken by the Orissa Mining Corporation before the Honorable Single Judge, Ballad, they are making a vote fast now. It totally a topsy-turvy. Source of the stand of the state government.
The learned single judge ought to have been said that these documents are not relevant and not in accordance with the observations which were made. So this is how
that of course that
is the only
it's my only duty to point out to that, This is what was the purport of the order.
We are also feeling very, very bad about it, that we have to again remand the matter back to the learned single judge. So as a matter which could have been decided, the matter must have remained pending for several years.
Yes, my lord. And especially pertaining to the pension of the people who have retired.
Still.
And aspect, well, one more, Lordship, if allows me, my lord, the aspect which has not been touched by the division bench earlier, but that aspect has attained finality. But that aspect cannot be allowed to be reopened.
All right.
And my lord, what I humbly submit, my lord, the documents which cannot be a document certainly which is post the delivery of the judgment. It has to be a document prior to the delivery of the judgment. That is what that is the reason it was rejected. Basically, both those language was different. Language different.
If any document was required to be rejected, then it could have been mentioned that this document cannot be, should not have been.
Well, there, of course, we have no control there.
We feel sorry.
Yes.
But still.
Well, now I put a question to myself. Would the case be developed after the judgment was delivered by saying those are the documents available? But the case cannot be improved.
That plea is available.
Well, Lakshmi, just sit that only one para of the judgment I am citing, 2011.
What for? It's a short point we are remanding. It's very simple. No much complication. But still, we feel sorry about the fact that the dispute could not be resolved. Despite.
Well, Lordship, we have got a lot of deliberation, but one thing, what is very important, the state governments have a right to prefer appeal. Writ appeal can be only by a person aggrieved. How is the state government aggrieved? It is a corporation having an independent entity, and what then something was argued that it is a 100% shareholder. Yes. But shareholder, what is the right and liability of shareholder? It has to take part in the general meetings.
You can take that plea. They are not writ
up. No, we had all taken those plea, I myself argued that point, I had taken that.
We have seen that.
May we permit it to add one? We can't improve. But you also read para 32 and 33. And the affidavit are elected. But there are certain judgment, of course, if you also permit me, I can place those judgments, not now. That is an intra-court appeal. Suppose the division bench found that there is some infirmity in the order. In that case, instead of remanding the matter, the division bench can also decide the matter, sir.
Oh, yes.
Yes.
That is what.
That's right.
So on merits.
You are right.
As you also right, but now, so far as this aspect is concerned, we can't improve. That is on record. So only thing is that the documents which were produced by the state by way of an affidavit, whether that has been considered or not, that is what also wanted to know. But that has been rejected. That could have been said, that has been dealt with in the judgment also, in the, either explicitly or expressly or impliedly, it has been dealt with. But so far as the affidavit has been rejected, that your Lordship has. We leave it to Lordship.
Well, I'll just read one time, only 2-3 lines in the para. 2011, volume 7, SCC, page 69.
See, by citing those decisions, the only service which you are doing is to the members of the bench, because we are noticing those decisions. We will be reading those decisions for being used in some other case. Not in this case.
Well, we have already read the Lordship's spine balance. I will not spoil more time. Only 2 lines, Malan.
Yes. 2011, volume 7.
SCC.
Yes.
Page 69.
59.
Paragraph 50.
Yes.
That's a good.
I'm not troubling lordship with the rest of the paragraphs.
Yes.
Only paragraph 50. At page 86.
Yes.
This court wants to make it clear that an action at law is not a game of chess. A litigant who comes to the court and invokes its jurisdiction must come with clean hands. He cannot prevaricate and take inconsistent positions.
So this observation is confined to
Litigants.
writ jurisdiction. Writ jurisdiction must come with clean hands.
Yes. So that is the reason what I said. State government takes a stance and mining corporation takes a stand before the writ court.
So they had not invoked writ jurisdiction.
They're appearing against, of course, either writ jurisdiction.
All right.
Well, just to
The world fast they cannot.
just to complete records.
Not by non-pen rate. Para 34, the Honorable Single Judge has also referred to that. The impugned judgment at para 34, in view of the law laid down by the Appellate Court as mentioned supra, this court is of the considered view that action of law is not a game of chess. Therefore, the litigant who comes to court and invokes the writ jurisdiction must come with the clean hand. That is what the Honorable Single Judge, the impugned judgment at para 34.
Single judge is right, but
Yes, but that part, Lordship,
But just to complete records, much was said that's why state has challenged. I appear for Orissa Mining Corporation. We have also filed 3 appeals. So that
no, that is there.
I'm great.
That we have.
I'm great.
and so far the Orissa, with all respect, so far the Orissa Mining Corporation is concerned, they had not preferred any appeal against the order of the Honorable Single Judge at the first instance.
That was also recorded by the learned division bench.
Maybe.
It was first.
Now the question is, after the matter was remanded, that is for your worship to decide whether at the instance of the Orissa Mining Corporation, whether they can again prefer an appeal, particularly when they have accepted the judgment.
Anticipatory observation.
And Mullah, it is the mining corporation preferring appeal against their own wisdom.
That's a different.
They decided everything in favor of the implementation of the
I did
scheme.
not want to comment on this. Repeatedly it is being said, but that very proposal of Orissa Mining Corporation was subject to approval of the government. Anyway, that's not a matter for us.
All right. These appeals have been referred by, intra-court appeals have been referred by the state of Odisha and the Odisha Mining Corporation Limited, a selling and order dated, judgment dated 23/12/2021, passed by a learned single judge of this court in WPC number 8554 of 2014 and other matters and other connected matters.
Same judgment.
Connected matters. Full stop. Next. It is noteworthy that where is the first order? First order. It is noteworthy that how many writ petitions were there?
My 3 writ petitions are there. You can find it from page 99.
3 writ petitions. That is WPC number 1018 of 2014, WPC number 8554 of 2014 and WPC number 18578 of 2015 were filed by the employees of Odisha Mines Corporation Limited, Mining Corporation Limited, seeking issuance of a writ of mandamus to the opposite parties to extend the benefit of pension scheme at par with the employees of similarly situated public sector undertakings. Full stop. All the three writ applications were heard together by a learned single judge. Full stop. The learned single judge by a common judgment and order dated 29/1/2019 passed in all the three cases, allowed the writ petitions holding in paragraph 18 and 19. 19 has been typed as 17.
Paragraph 26,
So just a minute. 18, 17 has been wrongly typed. Yeah. 18 and 19. Can you see that?
17, 18, 19.
Come to page 124.
Well, that is 18.
18 and next paragraph?
19 madam, at 125.
18 and thereafter. Oh, so sorry. 18 as under. So stop. Then single judge further held in paragraphs 25 and 26 as under. So stop. The next. The said judgment of the learned single judge became subject matter of challenge in intra-court appeals filed by the Odisha Mines Corporation Limited.
No, State of Odisha.
By the state of Odisha. Those appeals were filed by the state of Odisha. State of Odisha giving rise to WA 129. Giving rise to WA number 445, 612 and 613 of 2019. Stop. A division bench of this court, after having considered the rival submissions advanced on behalf of the parties, in its common judgment and page 120, 125. Can you get 129? But the division bench by its common judgment rendered on 22/6/2021 concluded as under. Paragraph 30. '31. And 33. '31 and 32. So stop. The division bench further observed in paragraph 33 as under. So, bold. Emphasis added. So stop. Upon it is not in dispute that in the light of the observations made by the the division bench in so and so, WA number so and so, as noted above, comma, the comma, an affidavit was filed by the state of Odisha, filed by the state of Odisha within the time stipulated in the order of the division bench. Stop. The affidavit filed by the state of Odisha was, however, rejected by the learned single judge on remand. Where is that order?
8/12/2021, page 241.
241.
241.
Was rejected by the learned single judge by an order dated 8/12/2021 in the following terms. Paragraph 2, page 241. Full stop. Next. It is one of the grounds taken on behalf of the appellants in the present batch of appeals that the rejection of the affidavit by the said order dated 8/12/2021 is manifestly in teeth of the observation made by the division bench in the judgment dated or subsequent date in WA number previous. Stop. It has been argued on behalf of the appellants that in view of clear observations made by the division bench, learned single judge ought not to have it 12/2015. ठीक है ना? इसके बाद जितना है उसको काट दो. After having rejected the affidavit by the aforesaid order dated 8/12/2021, the current single judge allowed all the writ petitions on remand by a judgment and order dated 23/12/2021. Stop. The said judgment dated 23/12/2021 is under challenge in the present batch of intra-court appeals. Stop. We have heard so and so. It has been argued on behalf of the appellants that the decision rendered by the impugned decision rendered by the learned single judge is in teeth of the decision of division bench in case of in WA whereby the learned single judge, whereby the Orissa Mining Corporation Limited, OMC in short. OMC was given liberty to file an affidavit by the state,
To the state, not to OMC.
to the state of Orissa to file an affidavit which was rejected by the learned single judge. So stop. Next. Arguments have been advanced on behalf of the respondents on various aspects, including the scope of intra-court appeals. Stop. It has also been argued on their behalf that in the facts and circumstances of the present case, the state of Orissa did not have a locus standi to maintain the appeal. This is what you have submitted. Stop. Learn per contra, comma, it has been argued on behalf of the appellants that OMC has also preferred appeals and the state government of Odisha being party to the writ petition had a right to question the correctness of the order of the decision of the learned single judge. So stop. Learned counsel for the parties have relied on certain decisions of the Supreme Court, which we are not required to consider and refer to in view of the opinion which we have formed and the nature of order which we intend to pass in the present matter. So stop. Next. We are satisfied on reading of the division decision in case of division bench decision dated first division bench
22/6/2021
dated 22/6/2021
page 129
passed in WA number 445, 612 and 613 of 2019 that the learned single judge ought to have addressed the affidavits filed by the state of Odisha in view of the nature of observation made in paragraph 33 thereof. So stop. On the sole grounds of a rejection of the affidavits filed by the Odisha filed on behalf of the Odisha state of Odisha in tune with the observation made in paragraph 33 of the judgment dated so and so, comma, the order of the impugned judgment of learned single judge deserves interference. Stop. Accordingly, the order dated so and so is hereby set aside. The matter set aside. Consequently, WP so and so are directed to be restored to their original files for them to be heard by a learned single judge of this court having roster. So like dealing with the roster. Stop. Appeal is allowed with the aforesaid observation.
No, ordinarily, matter disposed of by the same judge, it should be limited back to that very judge.
No, not this. It is now roster. They will go to the roster.
Ordinary courts,
Jurisdiction now. The honorable.
if it has been disposed of by the judge, was heard this matter in extension, and you can also be remitting matter to that.
No, it should not be done. It becomes all right. I'll see.
No, it should go to the roster judge. That is how it is.
We will see. No, before whom the matter will go, we don't.
Fair enough. You should have said that roster bench. You know, she said that roster bench. That is what.
You will be the master of the roles in any case.
Tell me. Or leave that to us.
Only blood to assist the Lordship in this controversy, my lord. Lordship knows in that the Pradhani judgment, the Honorable Supreme Court said that if bail apply, Pradhani
is different.
No, what is the
bail is different.
I don't understand the anxiety.
Please don't.
Just the reverse.
Well, no. It's not the question of anybody's anxiety, but it's not fair to make such a comment. It's up to Lordship. It's up to Lordship. They have no choice, but it has to be as per Lordship.
Twice it has been met. That is why the judge has.
I'll make corrections.
We will give our appearance slips.
One that is also fix up a time limit because
we should not do it. Intentionally, I have not done that.
A request can be made.
Not with this intra court. The Supreme Court says at times.
Even the Supreme Court says request to the High Court.
Yes, Supreme Court says, but the High Court should not say even that. Therefore, I have intentionally not done.
Fair enough.
Only
but still, as Chief Justice, I assure you that I'll see to it that disposal is expedited.
That's great. That's it.
Item number 33.
Item 33, my lord, kindly give me 10 days back.
33. All right, as requested. On behalf of the tenant. Push this matter on. 2 weeks. 2 weeks, Mr.
Item 34.
My lord, this matter pertains to recruitment of homeopathic medical officer under Health and Family Welfare Department, Government of Orissa. OPSC had conducted a written examination for recruitment of the medical officers, homeopathy medical officers. Here, this case, the appellant, she appeared and she had answered the questions number 10, 97 and 100 correctly. But the answer she had marked, which did not tally with the key answer sheet of the OPSC. Accordingly, she was deprived of the appointment offer. So here, the single judge, honorable single judge has rejected this case on technical ground, stating that there is no provision for re-evaluation. But here, the appeal is not re-evaluation, but giving the correct mark for the questions answered correctly.
That cannot be gone into, the Supreme Court has repeatedly said. Then we cannot go into, the High Court cannot become experts. The appellant has put to challenge in the present intra-court appeal an order dated, judgment dated 22/2023, passed by a learned single judge of this court in WPC number 21213 of 2017. So, in nutshell, the case of the appellant is that she had applied for the post of homeopathic medical officer pursuant to an advertisement number 23 of 2015-16 issued by the concerned departments of the state of Odisha. So, her name, however, did not figure in the selection list. He filed the writ petition seeking direction to declare her qualified for recruitment for the said post. Stop. Next. It is not in dispute that the only ground which was taken by the appellant in the writ petition was that the model answer key for the questions number 10, 97 and 100 were incorrect, whereas the petitioner had marked correct answers in the multiple answer type, multiple choice question type test. So stop. When single judge, however, when single judge dismissed the writ application mainly on the ground, dismissed the writ petition, noticing the Supreme Court's decisions in case of Bihar Staff Selection Commission and others versus Arun Kumar and others. His citation is not given.
It's given, sir. Case 12 of the order.
Sorry, so pardon. Hang on, Supreme Court's decision in case of Pramod Kumar Srivastava versus Chairman Bihar Public Service Commission and others. Stop. Next. Learned counsel appearing on behalf of the appellant has argued that the learned single judge ought to have gone into the correctness of the stand taken by the petitioner in her pleadings in relation to the said questions number 10, 97 and 100. Full stop. Next. After having heard learned counsel appearing on behalf of the parties, on behalf of the appellant, and perused the impugned judgment of the trial court, we are of the view that the same does not suffer from any legal infirmity. Stop. The writ court exercising jurisdiction under Article 226 of the Constitution of India is not required to enter into the correctness or otherwise of answer key prepared by the experts unless something shown to be to the court to be manifestly wrong. Stop. The impugned decision does not require interference. Stop. This appeal is accordingly dismissed.
Item number 35.
May I please your worship? The Odisha Legislative Assembly issued an advertisement for recruitment of reporters for the Assembly. Now, the petitioner and the opposite parties number 2 and 3 were participants there too. As the process of selection became vitiated, the petitioner who was unsuccessful challenged the process of selection. And the opposite parties number 2 and 3 who were shortlisted for selection, they also filed a writ petition saying that though we have been selected, shortlisted, we should be given appointment. So 2 writs were taken up together and heard. Well, I'll straightway take your lordships to the writ petition filed by the present petitioner, Annexure 1, wherein I had extracted at page 21 a note of dissent given by the selection committee.
No, but if his writ application is or if it's allowed, if appeal is dismissed, then you will be happy?
His appeal is dismissed, then I'll be happy. No, I'll not be happy because this has to go. He has not filed any appeal. He is successful.
He's successful.
He is successful.
He had also a grievance.
No.
Whether
There were two writ appeals.
Two writ petitions. Writ petitions, only one writ appeal.
Mr. If we have been able to understand the things correctly, then there was one selection process.
Yes.
You were declared unsuccessful.
Yes.
They were declared
Successful.
Despite them having been declared successful, they have not been appointed. And
If your lordship permits me, my lord, I am for the assembly. We had assailed the order of the Honorable Single Judge saying that the entire selection process being tainted, we had taken a decision to cancel it. And the law secretary had given an opinion. There was a legal opinion from our side also that we had taken proper legal opinion.
So, did you file any appeal?
We filed an appeal. During the pendency of our appeal, the order of the Honorable Single Judge was worked out.
No. Where did you file appeal? Against which order?
Against the very same order which is assailed by my learned.
There are two orders.
No.
Same order. So
how many appeals are there?
Only one appeal is there.
As on date, today you are actually only hearing one appeal.
Then we can hear all the appeals.
No, the other appeal was infractuous because, my lord, if your lordship takes the last paragraph of the operative portion of the Honorable Single Judge's order, I think it's a short 5-7 lines, 10 lines.
Whose appeal is this?
It's mine.
Whose appeal is
Mine.
this? Who are you?
Oh, okay. Well, so I assailed it on the ground that selection process was vitiated because the selection committee, members of the selection committee had given a note of dissent.
Which they are also saying the same.
Yes, madam. And a note of dissent. Now, the bone of contention is the learned single judge, while deciding, held that there is no note of dissent.
There is no
note of dissent in existence. Because all that has happened, if your lordships will take page 63, that's a part of the counter filed by the Legislative Assembly. Paragraph 8. May I read, my lords?
Yes.
Paragraph 8. It is revealed from the subsequent developments that the examination committee had raised their note of dissent to the process of selection because of alleged wrongful influence inter alia of the deputy secretary cum chief reporter who happens to be the father of opposite party number 2. Hence, due to dissenting note of the selection committee and final result appointing the selected candidate was not published. Now kindly see the findings of the learned single judge. Page 97. Last line of that page.
Yes.
With regard to the original note of dissent aforesaid, note number so and so reveals that OSD cum secretary has noted in that file that the original note of dissent was received by him and the same was forwarded to Srimati Baijant Patnaik, Under Secretary of the Establishment Branch. However, it has been finally stated that original note of dissent is not found in the branch, and as such, it was presumed that the original note of dissent dated 29/8/21 is with Srimati Patnaik, Deputy Secretary. She was directed to submit the original note of dissent. Thereafter, over the page at page 34, paragraph 34, third line. Moreover, this court observes that the original note of dissent does not exist as Srimati Patnaik, who was allegedly received the note of dissent, marked to her, stated that she was on leave on that particular date. And thereafter at page 100, last 10 lines from the bottom of the page, sentence beginning most importantly. We're in the middle of the page. most importantly, the relevant document. Have your lordships got that? Most importantly, the relevant document, there's the note of dissent as it appears from the record.
Page 100.
Page 100. Page 100, about 12 lines from the bottom of the page. Sentence beginning, most importantly.
Yes.
Most importantly, the relevant document, that is the note of dissent as it appears from the record, has not seen the light of the day. Therefore, the court asks itself a question as to how far it would be justified in taking cognizance of such a note of dissent, which finds out not mentioned in the note sheet from 28/9/21 to November 22. Further, this court is of the view that had the selection board meeting been conducted in due time, the petitioners would have been appointed by now. In such view of the matter, the court has no hesitation in coming to a conclusion that no note of dissent exists. At least the same is not available on record despite the best attempt of the Secretariat of the Odisha Legislative Assembly to trace out the same. Hence, the same shall not be taken into consideration while deciding the present case. These were the vital aspect of the case which bore on the mind of the learned single judge while deciding the issue. That is why, my lords, in the meantime, I have obtained the note of dissent under the Right to Information Act, and I have filed it by way of an affidavit before this court on 13/9/23. There is a note of dissent, and acting upon this note of dissent and the learned single judge's judgment,
No, but here is a case where the employer himself is of the view that there were irregularities in the process of selection.
Absolutely. Absolutely. And they've scratched it. They scratched the entire process, and that is why my learned friend's client has also filed another writ petition challenging that cancellation of the selection process. But my prejudice is the the finding of the learned single judge that there is no note of dissent.
What will you get?
Well, if the note of dissent goes, then obviously the new selection process would, the old selection process would stand terminated, and the new selection process can take place.
All right, that's all.
That's all.
My lord, may I submit, my lord, I am the person, respondent number 2 and 3, who were selected. My lord, what happened when my respondent number 2 and 3's name, when they are put up in the final list, under the Legislative Assembly rules, a selection board has to sit. It has to approve it.
Because, no, what right do you have to be appointed?
Yes. May I, paragraph 25, my lord, may see. My lord, in the 2 writ applications, one filed by me, one filed by them, they took 2 different stands.
No. Our question is, what right do you have to be appointed?
Yes, my lord. May I, my lord, there are 2 aspects to it, my lord. First is, I have relied on a decision of the Honorable Apex Court, that is Dinesh Kashyap, that is a 3-judge bench, where the Apex Court has held that even if a person is there is in a select list, he has no inherent right to be selected. But there is a corresponding duty on the authorities to see on the touchstone of Article 14 that why they will not give him appointment.
So this is what they are saying.
Yes, that is what I'm saying out, because, my lord, what happened when this was, when there are 2 counter affidavits was filed. If your lordship will see page 87, there the single judge has given a categorical finding. In the first writ application, which was filed by me, there is not a single whisper about the written note of dissent. In the second writ petition filed by them later, they raised this plea of a written note of dissent. That is why the single judge, my lord, categorically called for all the original documents pertaining to the selection process and gave a categorical finding after going through them that no such written note of dissent exists. That is my first limb of submission, my lord. The second limb of submission is, my lord, when this writ appeal was filed by the failed candidate, there is no pleading about the written note of dissent which has been filed in the writ appeal.
No, even if we forget.
My lord, may I show just 2 things I want to show your lordship. I have understood what your lordship wants. Kindly see, my lord, page 30. Because, my lord, before the single judge, in the 2 writ applications, no written note of dissent was ever produced. 1. Secondly, my lord, when the writ appeal was heard by your lordship's previous bench, they suddenly produced a photocopy of the written note of dissent. When I objected to that, then they were directed to file by way of affidavit. How they have obtained it? Because the surrounding circumstances, when the single judge had called for categorically those things, it was never produced. He gave a finding, it is never there. So they filed an affidavit saying that we have obtained it under the RTI Act. Kindly see, my lord, that document. That is the, my lord, manipulated document. Your lordship knows, under the RTI Act, when a document is called for, that has the seal of the PIO, Public Information Officer. Here,
Sir, the problem is that if the employer is satisfied, employer satisfaction is paramount. So it is his discretion whether to appoint a selected candidate or not. If the employer itself is satisfied that there were illegalities or something, and the selection list should not be given effect to, they are free.
my lord, I bow down to your lordship on the general proposition of law, but that satisfaction must be based on materials on record when a list is pending before this honorable court, which they could never produce. Kindly see page 30, my lord, for a moment.
Yes.
Before going to that document which they filed by way of an affidavit, page 30 is their application before the PIO. They say that the PIO never gave us this document, but what is there in that document, they have reproduced it in the writ petition filed before them before the single judge. That is my first leg. Now coming to the second part, your lordship may kindly see the written note of dissent that is dated 30/9/2023. There, the written note of dissent bears the seal of the Orissa Legislative Assembly given, my lord, produced after a period of more than 2-3 years. So this is a document which has no veracity, my lord. Legally, it has no value, my lord. It is a document created to get over the order of the honorable single judge. And that is what is my objection. Because under RTI, my lord, when this issue was raised, I filed an RTI query whether such a document exists or not. And they gave a categorical
We in fact, I have not been able to lay my hands on. There are decisions. There is a decision of Supreme Court that decisions cannot be taken. The adjudication cannot be done, or the courts cannot decide issues on the basis of informations received under the Right to Information Act. So that is that.
But my lord,
yes,
I will humbly say that in this writ appeal, when they did not annex that document, when they filed a photocopy of it,
so therefore, you are also relying on some information which you had received.
Not for a moment, I am not relying on that information. I will only rely on the findings of the single judge.
Simple question involved in the present proceeding is as to whether you have any right to be appointed based on your selection or not. That's the only thing.
My lord, that already
say no.
Pursuant to the order of the honorable single judge, they have already rejected on the grounds which were prohibited by the honorable single judge, and another writ petition is pending that are filed by way of affidavit. Now, because the unsuccessful party has come up, because what has happened, my lord, when the 7 vacancies were there, they were for various categories. General category, SC, ST, OBC. Now, the respondent number 2 and 3, one of them belongs to the general category, one of them belongs to the SC category, and the appellant belongs to OBC. So, the general law is, my lord, a person belonging to one category cannot challenge the appointment of person belonging to another category. That judgment of the apex court have given, it is there with you. So, what they have done to get over it, my lord, they have challenged the selection process itself, saying that the process itself is illegal, my lord. Now, if the process is illegal, it was tested before the honorable single judge. Let us not go into the RTI part, my lord. I will not go into that. I will simply rely on the findings. So, where is the perversity in the findings of the honorable single judge, which would force your lordship to set aside this order? Because this very document, their only case is that the irregularities are based on a particular document. Now, if that document is not produced in the writ petitions, even before the single judge, when the original documents were called for,
you are not required to repeat your submission.
Your lordship has understood. So, what my humble submission is, the honorable single judge's order twofold, my lord. One, it has worked itself out.
All right.
Second thing is, my lord, from the materials on record.
All right. Let him also argue.
Yes.
He is for you or he is against you?
He is against me. He is for the Legislative Assembly. I am for the successful candidate.
So you are the only thing. You are fighting against two stalwarts.
my senior brothers.
My lords, in any event, the whole my lords, debate might have become academic because of the last observation. Page 115 of the judgment of the Honorable Single Judge. Accordingly, this court directs the opposite party number 1 to immediately convene a meeting of the selection board in terms of Rule 7.2 of the Rules 1983. The names of the selected candidates which were uploaded in the website of OLA.
115.
115. Prior to that, I'll take your lordships to 109. The very
115, which
and the last of the brief of the running page 115. That's the judgment of the Honorable Single Judge.
oh, there, 171.
Prior to that, your lordship may kindly have 109.
Which line?
115, my lords, 10 lines from the bottom. Accordingly, this directs the opposite party number 1 to immediately convene a meeting of the selection board in terms of Rule 7.2 of the Rules 1983. The names of the selected candidates which were uploaded in the website of Legislative Assembly dated 28/9/2021 be placed before such selection board. Thereafter, necessary action be taken by the opposite party number 1 pursuant to the decision of the selection board, and the Honorable Speaker within a period of 8 weeks from the date of communication of a copy of this judgment. It is further made clear that in the event the selection board gives its concurrence to the list of selected candidates, then the opposite party shall do well to giving the petitioner's appointment against the post. So there was a mandate to give them appointment. So it was always there, my lords. Your lordship may kindly have page 109. My submissions, page 109.
Yes.
Para 41. Learned Senior Counsel appearing for the opposite party number 1 assailed the prayer in the writ petition on the ground that mere placing or positioning of the name of the candidates in the select list does not confer a vested right to be appointed against the said post. In this context, he has referred to the judgment so and so. On perusal of the judgment, this court is of the considered view that the law pronounced by the Honorable Supreme Court in the aforesaid judgment is quite well settled, and therefore the same does not require any further discussion. Then, my lords, this second paragraph, page 42. So, Learned Senior Counsel further took a plea that the writ petition is not maintainable on the ground that the same is premature, as the selection process to the post of reporter is not over. It was merely the, my lords, examination committee which recommended the name. The final selection, my lords, had to be done by the selection board. And thereafter, my lords, the speaker is to put his stamp of approval on the, my lords, names. So what had happened here, there was, my lords, gross, my lords, tampering and manipulation of the, my lords, mark sheets and the tabulation sheets and, my lords, all the connected papers. So therefore, my lords, when the selection board convened, the selection board wanted to see the original records because of this allegation of tampering. Those records also could not be produced before the selection board. Selection board consists not only of the, my lords, members of the assembly, also the opposition and my lords, other dignitaries are there on the selection board. So they could not come up, and there was no satisfaction, obviously, because there has been tampering, and our stand is that all along, my lords. We have been trying that, my lords, horse that the selection process has been tainted. This is not the way how you appoint persons to the public post, my lords. So therefore, the selection board did not approve, scrapped the entire process, said go in for fresh selection. So our writ appeal was filed. During the pendency of our writ appeal, my lords, this order of the decision of the selection board came. Thereafter, my lords, we withdrew the appeal. Obviously, because my friend has also challenged that second, my lords, that order scrapping the process.
That is pending.
That is pending. During the pendency, my lords, out of deference to the Honorable Court, my lords, even though no formal stay order has been granted, we are unable to proceed with the final hearing, my lords, advertisement or anything else, because naturally, because the Honorable Court is in session of the matter. So therefore, my lords, I leave it to your lordships which way.
No, my lord, I seriously, my lord,
If your lordship
to the submissions led by the learned senior counsel. First submission is, my lord, if they were so much bothered about the irregularity, when they filed the writ appeal, why did they allow it to work out? The grounds they are raising here, they could have very much raised it there.
See, you are a young counsel.
There was no mandate to.
And very competent. So therefore, we are telling you this. Don't point fingers towards the court.
I'm extremely sorry. I'm sorry.
All right.
Sorry. Sorry, my lord. Sorry.
All right.
There was no.
So now the writ, this appeal has lost its efficacy in view of the subsequent developments. You have already filed your writ petition. You try your luck there. All right. The selection process is according to
My only prayer.
so you can whatever submission you are making here, you can make there in the before the writ court. All right.
My lord, if your lordship dismisses it simply on those grounds, then
No, we are just holding that in view of subsequent developments, the question which is involved has become academic. And you are at liberty to
My lord, what will
My friend's anxiety can also be addressed. If my learned friends, my lord, if your lordship direct that the disposal of the writ.
have you filed this
petition.
appeal?
Pardon, my lord?
Have you filed this appeal?
No, my lord, I have one.
And he has not challenged that.
You have not filed this appeal. So we are just disposing of this appeal with your permission.
No, my lord,
That now because it has become the issue, the dispute does not survive anymore because of subsequent developments. You will raise all the points which you are raising. In the present judgment of a learned single judge of this court dated 19/5/2023 rendered in WPC number 31988 of 2021, bracketed Saurav Rawat and another versus the Odisha Legislative Assembly, Bhubaneswar and others, is under challenge in the present intra-court appeal. So stop. From the materials on record, it transpires that the dispute relates to selection and appointment to the post of a reporter in Odisha Legislative Assembly. So stop. You were respond number?
My lord,
Opposite party number? Huh?
my lord, in the first writ application, we were the petitioners, and in the present appeal, we are respondent number 2.
You are Saurav Rawat.
Saurav Raut and another, my lord.
You are Saurav Rawat and another.
Two petitioners were there. 2 writ petitions were disposed of by that common order. Your lordship has indicated the first.
Saurav Rawat and Satyanarayan.
Maharana is there.
Maharana.
That is Saurav Raut and Vishwajit Behera.
And the said selection process, the petitioners, Saurav Rana and another.
Saurav
Raut and
Vishwajyoti Behera.
And Vishwajyot Behera claimed to have been selected. Stop. Satyanarayan Maharana, petitioner in WPC number 6171 of 2022 was unsuccessful. Stop. Saurav Raut and another approached this court seeking a direction with a grievance that despite their selection, the Odisha Legislative Assembly was not appointing them.
Or the selection board of the Odisha Legislative Assembly. Actually, as per the rules, after the final list is uploaded, the selection board has to sit and approve it.
All right. Selection board two?
Selection board of the Orissa Legislative Assembly.
No, you were seeking direction to selection board.
Yes, my lord, because selection board had adjourned its signed that approval part.
With a grievance that the selection board of Odisha Legislative Assembly was not proceeding further
With their approval.
in the matter. Stop. The petitioner Satyanarayan Maharana in WPC number 6171 of 2022 questioned the legality of the selection process itself. Correct? Stop. Next. The writ petition both the writ petitions were heard together and came to be disposed of by common judgment and order dated so and so. Oh, public. Stop. Next. It has been pointed out by Mr. Palitlan, Senior Counsel appearing on behalf of the Legislative Assembly, that during the pendency of the present appeal.
No, madam, their appeal, that is 1458 of 2023. They had also filed an appeal.
All right, but during pendency of this appeal also.
Also.
During the pendency of this appeal, the selection board of the Odisha Legislative Assembly has taken a decision to cancel the entire process of selection and proceed for selection process afresh for appointment to the post of a reporter. Stop. It is noteworthy that a writ appeal was preferred on behalf of the Odisha Legislative Assembly also, giving rise to WA number
1458 of 2023.
1458 of 2023, which has been withdrawn
on 4/8/2023.
On 4/8/2023 because of the subsequent development, that is cancellation of the selection process itself. Stop. Next, the petitioners of your respondent number?
I'm respondent number 2 and 3 in the present.
Respondent number 2 and 3 in the present intra-court appeal, who were writ petitioners in WPC number
319,
have filed a writ petition before this court, assailing the decision of the Bihar Legislative Assembly to Odisha Legislative Assembly to cancel the process of selection. Decision cancelling the process of selection and to start a selection process afresh for filling up the post of reporter. Stop. Next. Huh?
Once I can give that number also, which is now present. Okay.
Stop. In view of the subsequent developments, in our opinion, the questions involved in the present appeal have become academic. Stop. This appeal is accordingly dismissed, disposed of. Stop. Next, we make it clear that we have not gone into the disputes raised in the present appeal, and no observation made in the present order shall be treated to be an opinion on the merits of the case. Yes.
Right, 36.
My lord,
Yes.
similar matters my lord heard on the last occasion on 2024, where my lord remembers because of Rafiq Mashi and he being a class 3 post holder. So recovery we cannot make. But I made a submission to this honorable court that yes, we cannot make recovery, but subsequent refixation we can make, for which my lord also gave some other observation and disposed of those cases. Now this case was also along with that, but on my mention it was deleted from that. Here, my lord, this honorable court, honorable single bench has held that no, he is entitled.
Yes.
Therefore, this order is under challenge. Now, I will take my lords to only three. My lord, first of all, Rafiq Mashi, we cannot recover. That is the admitted position, my lord. My first submission. Now, my lord, on disputed facts, here he is a driver Havildar.
He is a driver.
My lord.
Driver Havildar.
No. He retired on 30/4/2019. Now, third thing, when we sent his pay fixes was made, according to us, we made a wrong third RSCP. Pay fixes was made, sent to the AG office. From AG office, it was returned to us with objection. After which we started all this process, my lord. Then obviously after retirement, only all these things have started. Now, my lord, these are the undisputed facts. Now, my lord, I will only tell three things. The post is fireman or fireman driver is the initial post. Fireman or fireman driver. Then the next promotional post is leading fireman or driver Havildar. 2. Then the third, next promotion post is assistant station officer. From assistant station officer, station officer. These are the 4 posts, man. Now I will take, my lord, only to the very notification which entitles a person for RSCPs in different modes. I will take, my lord, to the notification of 6/2/2013, that is under Annexure 2, my lord. May I take, my lord, to Annexure 2?
This is your submission.
Yes.
That you will not recover the amount which was paid to him.
We cannot.
You cannot. Then you want that his pension should be refixed.
Ma'am.
On the basis of what he was actually entitled to.
Ma'am.
What is wrong in it?
Well, I'm entitled for it.
You are entitled.
Entitled for it. That is hold by on the losses is the judgment on the silence. Paragraph 10, 11, my lord. Paragraph 10, 11, 12.
All right. Let him argue then.
Yes.
So, my lord, I will take, my lord, not to any other law, any other decision. I will take, my lord, to the very notification which gives rise to this claim. That is, my lord, will find it, please, at page 27 of my writ appeal. 6/2/2013. At page 27.
Yes.
My lord, I will place 2 paragraphs only. I will place the first paragraph and paragraph 10. The first paragraph reads like this, my lord. The state government considered the recommendations of the fitment committee and granted assured career progression to the state government employees on completion of 15th, 25th and 30th years of service akin to the time-bound advancement provisions of the Odisha Revised Scale of Pay Rules 98. Accordingly, all state government employees avail SCP in 3 stages. First SCP on completion of 15 years of service, second SCP after 25 years of service, and third RSCP after 30 years of service in their original post grade by addition of 1 increment at the rate of 3% on the basic pay plus grade pay with next annual increment after a period of 1 year from the date of sanction of SCP. The Government of India in the meanwhile had introduced modified Assure Career Progression Scheme for the central government civilian employees in supersession of the provisions of SCP scheme consequent upon implementation of the MSCPs by the Government of India, various service associations. My lord, this is not required. My lord, may straight away come to para 3. The taking into account the uncertain promotional avenues and career stagnation of the state government employees, government after careful consideration have decided to implement a career advancement scheme to be known as Revised Assured Career Progression Scheme, RACPs in short. The RACPs is to be effective from 1/1/2013.
Yes.
Then may I take my lord to paragraph 10. It is from 1/1/2013, my lord.
Yes.
Paragraph 10 is important, my lord, for subject to my lord's acceptance, what I am submitting. Benefit of pay fixation available at the time of regular promotion shall also be allowed at the time of financial upgradation under the scheme, which means the pay shall be raised by 3% of total of pay in the pay band and the grade pay drawn before such upgradation. The employees of the cadre, well, this is important. The employees of the cadre having promotional hierarchy will get the grade pay of the promotional post. The employees in the isolated ex-cadre posts not having any promotional hierarchy will get the next higher grade pay as per the first schedule of ORSP rules 2008 with the interpolations, if any, introduced subsequently. In case of new grade pay corresponds to a different pay band, the employee will get the pay band corresponding to the revised grade pay. There shall, however, be no further fixation of pay at the time of regular promotion. My lord, our understanding, subject to my lord's acceptance here, is if I am getting a promotion and those promotional posts are within one cadre, then I immediately after 10 years, I get the grade pay of the next higher promotional post. After 20 years, I get the grade pay of the next higher promotional post. Now, my lord, I will again take back my lord. This is our understanding as per my lord, subject to my lord's acceptance. Now, I will take back my lord to the very first thing I said. The first post is fireman.
When was he appointed?
My lord, in the entire writ petition, there is no only thing.
You must be knowing. All right. Please.
No. The fireman or fireman driver. Next is leading fireman. Next promotional post is leading fireman. Leading fireman.
LEADING.
NG, my lord. Leading fireman or driver Havildar. Next is assistant station officer. These are in one cadre.
Yes.
Now, station officer is another cadre. Another cadre. It's not one cadre.
Fourth one.
Yes, ma'am. Now, madam, kindly see. The fireman has a grade pay of 2200. The next leading fireman has a grade pay of 2400. And the next, my lord, assistant station officer has a grade pay of 2800. Now, my lord, the station officer has a grade pay of 4200. He is not entitled to the station officer's grade pay, ma'am. The Honorable Court has granted that. Only I am submitting the notification, I am submitting his details, my lord. Yes, my lord, I cannot escape. There are similar orders, similar persons have been granted such benefit. It's a fact, ma'am. I cannot escape from it. As noted by, as argued by my lord senior in the writ petition, pleaded in the writ petition and observed by the Honorable Court in the order.
Oh, therefore,
but they were wrongly given. My submission will be they were wrongly given.
Maybe. Because we don't have all the facts also before us.
This is my case in very small, my lord. I have taken my lords to the notification.
Everything will depend upon the date. He may be, suppose he was entitled for the scale of, based on first ACP, he was entitled for 24.
Yes, my lord.
2400.
Yes.
There can be a circumstance that first SCP, he would be getting grade pay of 2,400, depending upon.
From the date of entry.
Yes.
Yes, date of entry, we have to count.
Obliged, ma'am.
20 and 30.
I bowed on, yes, that may be.
So
Then, my lord, 30 years, he won't get station officer. He will get in between. He won't get the cadre. The next cadre's grade pay he will not get. That is our understanding of para 10, my lord. Between 4,800 and 2,800, 2,400.
Between 2,800 to 4,400.
4,000, whatever grade pay available in the Orissa scale of pay first schedule, in between interpolation, he will get that grade pay only.
But others have been given.
Yes, ma'am, that I must also, because since there is observation, but it's only, that was my first solution. As my lord will pass.
Write the order. Write the order.
Ma'am.
But only one pair, 38 and 39.
38, I was praying for time, ma'am. Tomorrow, if my it's tomorrow.
Both on Monday.
Tuesday.
Your
Lordship. Just a minute.
38.
This was 37. Just a minute. The matter which we heard was 36 or 37.
My lord heard item 36.
Acha. 38 and 39.
Yes. Monday, Tuesday.
Tuesday.
Item 40. Item 40. Just 2 hours back, my lord, I got this additional epidemium and rejoinder, my lord, to respond it, my lord.
A rejoinder, you are not required to respond, but still, if you want to, you are.
Only, my lord, I'll 2-3 days. If your lordship can fix it in next
1 week.
Next week.
1 week, 40.
Lordship, item 41. 42, your lordship.
42?
I have received the counter yesterday. And your lordship, kindly grant me 1 week time for filing of rejoinder, your lordship.
Without any interim?
No.
All right. 40?
42.
42. 42 when? 1 week?
1 week for filing of rejoinder.
1 week at your request.
Yes, your lordship.
As requested on behalf of the petitioner, this is matter on 1 week, so as to enable him to file the joinder affidavit to the counter affidavit.
Yes, your lordship.
My lord, time permission. My learned friend just mentioned about item 40, where I am for the appellant. He's filed a vacation of stay and claiming for auto vacation on the ground of 226(3), my lord. My lord, he's praying for 1 week time. I am praying, my lord, let it be.
But tomorrow, my lord, no. Tomorrow.
Yes. Let it be there in the list. Yes. Item 40.
My lord, item 51.
Sir, I said item 40 may be taken up Monday only.
40.
48.
48. My lord, 48 Tuesday.
My lord, may kindly bring in 51 tomorrow within top 10 because it's an important matter. 51.
Make a mention tomorrow, we will take it.
If I am permitted to make a prayer, my lord. In fact, one item number 45. I am told that this identically placed matter, Lordship has been pleased to dismiss. An identically placed matter, Lordship has been pleased to deliver judgment. So that judgment is yet to be uploaded. We just need to go into that judgment.
It is uploaded.
Uploaded. So I just want to go through the judgment. If it comes tomorrow, then it will be difficult to my part.
How many?
It's that batch, that
45 cases, sir.
45. 40.
We have to also take any other case.
All right. Tuesday?
Tuesday will do, my lord.
Okay.
Tuesday.
45. 45.
45 items. They're bad cases.
Tuesday. Yes.
Item
Any other?
53, my please, minutes. Item 53, my lords,
Yes.
relates to the challenge made to the virus of a rule, the gate rules, my lords. Lordship should kindly keep the matter in top 10 priority, my lords. It's
53.
53, my lords.
So make a mention tomorrow. In the first hour, you can just make a mention that this is an urgent matter. It should be taken up.
My lords.
We will see.
I'll do. Deeply.
Who is appearing in 60?
60.
It's contempt. All right. That's
It has,
Yes.
I have filed my compliance affidavit, it has been complied with notes.
जितना contempt है ना.
I filed the compliance affidavit on 26th of February 2024, where we have stated that we have complied with lordship's order and passed the order on 15th of.
And what about 55? These orders have been complied with in other contempt cases.
Yes, 55, I've just lost them.
All right, we will take up other matters too.
Yes.